A few announcements before we begin with our program. And to start off, the restrooms are on the right. Please don't feel at all embarrassed to walk in front. I understand it's a bit complex navigating, but you'll be able to do that. The second important point is that in your bag that you received, the red bag you received when you registered, there are lanyards. If you prefer not to be photographed or be captured with the camera at all, please wear the lanyard. Otherwise, it is assumed that you are consenting to being photographed. We'll address consent a bit later, or Advocate Mohale will be doing that. But for now, if you wear the lanyard, it'll be assumed that you don't want to be photographed. The last point that I want to make is that the session will be live streamed to YouTube, so please just be aware of that and be aware of the cameras in your surroundings. But let's officially get started. Good morning, Chairperson, members of the Information Regulator, distinguished speakers, colleagues, delegates, and the broader privacy community. Welcome to Polokwane and the Information Regulator's commemoration of International Data Privacy Day. We meet today in Polokwane, a city which is considered, or at least the meaning of the city is considered a place of safety or sanctuary. And that's really a fitting location for a conversation about data protection, because at its heart, privacy is about trust, whether people feel safe and how their safe about how their personal information is handled, and whether institutions earn that trust in practice. This year, 2026, marks 12 years since the enactment of POPIA. You wouldn't think, eh? That places us, or should at least place us, beyond awareness and attention. The question before us now is no longer what the law says, but how it works or operates. And this applies to systems, organizations, and everyday decisions. I'm Nathan Ross Adams, and I'll be your program director today. My role is to keep us moving, keep us focused, and help us ensure that today's session remains practical and useful. With that, it is my pleasure to invite the chairperson of the Information Regulator, Advocate Pansy Klakola, to deliver the opening address.
Good morning. Good morning. Goeiemorgen. Dumelang. Ralocha. Abshin. That's good. I mean, it's International Privacy Day. It looks like, I don't know if guys you're tired or, I'm not sure, but I'm hoping that we'll be able to lift your mood as the day goes by. Apologies for starting late, as our program director has said. And I must say that I am quite pleased and elated to see such a high number of people who have joined us to celebrate this important day. And this tells us that there is a growing need for us to have continued engagement with stakeholders and members of the public on data protection and data privacy matter to improve the realization of this right, which is enshrined in Section 14 of the Constitution. We took a deliberate decision to come to Polokwane because we are trying, as you know, we don't have regional offices, but we are trying to take the regulator to the people. That is why we came all the way here. to commemorate this day with you. I would like to say good morning and acknowledge my colleagues who are here with me, Mr. Gwala, who is a member of the Information Regulator, and our CEO, Tate Musala, Nyana Musala, and all the executives who are here, the information officers, the deputy information officers of both private and public bodies who are here today, civil society organizations, academia, industry leaders, and members of the community. I'd like to greet all of you and welcome you to this event. As you know, every year on the 28th of January, we join the global community in reflecting on the enduring importance of the right to privacy, a right that sits at the very heart of human dignity and freedom. At the Regulator, we stress every time the fact that our mandate is a human rights mandate. We promote the right and protect the right to privacy and also the right of access to information. This day serves as a powerful reminder that as technology evolves, so too must our vigilance, our protections, and our commitment to upholding this fundamental right. International Data Privacy Day has become more than just an event. It has transformed into a critical platform for raising awareness and fostering discussions to improve data privacy. In our previous International Data Privacy Day programs, we have focused on specific areas related to data privacy. In some of the previous sessions, we looked into the issues relating to the following: promoting and protecting children's rights online. Most of you sitting in this room have got young children. You are young parents. And I have seen with young parents, because I have children who are young parents, you let gadgets babysit your children. That's what happens. For them to be quiet and so that you can go on with your work, you give them gadgets. And they are privacy, and sometimes you are not vigilant, you don't even know what is it that they are looking at. From playing Roblox to all these things that they play with. So I'm just saying this is an area that we need to be very, very vigilant about. Of course, misinformation and disinformation, it's a big issue, particularly during the election period, and we have looked at this. And you know that this year is a year for elections, 2026 local government elections, and we're going to see a spread of misinformation and disinformation. That's going to be heightened. Data privacy and curbing cybercrime, it's another issue that we've looked at, and also social media companies' compliance with POPIA, because we feel as the regulator that everyone has to comply, including digital platforms. This year's theme for this conference is 12 years of POPIA, what next? This seeks to take us back to basics, pause and reflect, and foster a culture of data privacy and improve the right to privacy. Today's conference invites us to take a deliberate step back, not to slow our progress, but to sharpen our focus. It is an opportunity to honestly assess where we stand after 12 years of POPIA enactment and 10 years since the establishment of the Information Regulator, 5 years after the full enforcement of POPIA. As the regulator, we have put in place many mechanisms to support public and private bodies to improve their compliance, which would in turn empower members of the public to assert their rights to privacy and protection of personal information. We have hosted several stakeholder sessions, community engagements, we call them dikopano, and training sessions to support this effort and raise awareness. We have developed 8 guidelines and guidance notes to support public and private bodies in improving their compliance. The public's right to privacy remains under significant pressure, as evidenced by the rise in complaints and ongoing challenges responsible parties face in implementing adequate safeguards. Advocate Buikanyo, who is the executive POPIA, will tell you, if my memory serves me well, that this year only, and the financial year has not ended, but how 800, am I correct? More than 800 POPIA complaints only. That's how pressured the environment is. Awareness gaps remain, as shown by the 2023 Public Opinion Survey, reminding us that we have more work to do in educating both the public and institutions about their rights and responsibilities. Ms. Shelembe, the Senior Manager of Policy, Analyst and Research, will share insights from the Public Opinion Survey we have conducted, including the findings, how we respond to them, and the recommendations to improve awareness. It's important to hear what people say about us so that we not sit there and just be delusional, thinking that everybody knows about the work that we're doing. So the survey will help us to improve. The environment around us has transformed dramatically. Data has become the currency of the digital economy. And with that comes increased responsibility for all who process it. Security threats are growing more sophisticated. Artificial intelligence is reshaping how personal information is used, and the expectations of the public in terms of transparency and fairness are rising. Technological advancements from AI to sophisticated data analytics are outpacing traditional approaches, demanding more agile and forward-looking responses. As regulators, we always play catch-up to technological advancements. I'm looking forward to the discussions that will arise from the session on innovation and accountability, and importantly, the recent amendments to POPIA regulations call for a renewed dedication to compliance, transparency, and accountability across all sectors. Newly amended POPIA regulations, effective since April 2025, signal an important shift towards stronger transparency, stricter consent requirements, and firmer obligations on responsible parties. The regulator has embarked on a process to review and propose reforms to legislation to improve data protection and data privacy in this evolving environment. The need for legislative reform is not an admission to failure. It is an acknowledgement that the digital world does not stand still. As technologies evolve, the regulatory framework must evolve with them. The review process is an opportunity to strengthen areas where challenges persist, modernize provisions that no longer meet current realities, and ensure that POPIA remains robust, fit for purpose and the future, and is responsive. Today, we gather not just to talk about data privacy, but to deepen our collective understanding on how we can make compliance practical, achievable, and effective. This conference is deliberately structured to help us move beyond statutory texts, to explore solutions, unpack challenges, learn from best practices, and strengthen the partnership we need to safeguard every person's personal information. Most importantly, encouraging organizations to adopt privacy respecting behaviors. This is not just a day of dialogue, but a day of empowerment where each participant lives better informed, better equipped, and more confident in their ability to protect personal information in their respective institution. Let us now begin a day of meaningful reflection, shared knowledge, and collective action. We are here not only to speak about the law, but to share practical approaches and tackle what obstacles remain and what solutions are needed to build a culture of privacy that goes beyond tick box exercises. I encourage that we all engage in robust discussion and find solutions to improve data protection and data privacy. Let me end by wishing all of us a happy International Day for Privacy. I thank you.
Perfect. Thank you very much, Chairperson. That opening sets the tone for today, one that asks us to look beyond compliance as an idea and towards compliance as a lived reality for everyone. And so I think it's fitting, or rather fitting, that we ground the conversation in public experience. For session one, we'll be looking at a reflection on the public opinion. So to ground today's session in public experience and perception, we'll hear a view on public opinion regarding data protection. And I'm not talking about public opinion on social media about whether your child's school has a Woolies tuck shop or not. That's not what I'm talking about at all. What I'm talking about is the views of the public, their attitudes, their beliefs about privacy, and how it's being expressed. So with that context in mind, I'm pleased to invite Ms. Hlengiwe Shelembe, Senior Manager for Policy Analysis and Research at the Information Regulator.
Daisy. Oh, okay. But where is the presentation? This one. But it's not clicking it. I gave it to them. Oh, okay. Good morning, everyone. And also happy International Data Privacy Day to everyone. It is such a privilege and also a pleasure to me to be speaking after the chairperson of the Information Regulator. As indicated, my name is Hlengiwe Shelembe and I am the Senior Manager for Policy Analysis and Research at the Information Regulator. What I'm going to be doing today is to share a few insights or brief insights, as I've been given just 10 minutes to speak about this, which is a project that actually took about a year to finish or to complete, but I'm giving 10 minutes just to briefly speak about the findings, recommendations, and how we have responded to them as the Information Regulator as well, because when we do undertake such a process, we don't just do it for the sake of doing it or for compliance, but we do it so that we can be able to get insights and findings that we're going to further integrate into our public awareness initiatives and respond to the needs of the data subjects on the ground. And just briefly, the Information Regulator does undertake public opinion
surveys on periodic basis so that we can get insights and also views of the public in terms of how they see us as the organization, and also to get to understand their needs in terms of how we can respond to them and teach them and educate them about their rights to privacy. So this particular public opinion survey that I'm going to be talking about today is the one that was concluded in 2023-2024 financial year, and we have thoroughly engaged on the findings and recommendations as an organization just to make an assessment in terms of how we can further integrate those into our different initiatives or outreach initiatives that we have as an organization. As I have indicated, the presentation does cover the background information on the public opinion surveys that we have conducted, because I can't just speak to you about the public opinion survey or the findings thereof without giving you thorough background in terms of that particular project. It also does cover awareness and also knowledge about the regulator and its functions, because before we can even try and get to understand or get insights from the members of the public in terms of how they feel about the information regulator, if they are able to articulate or assert their right to privacy, but we need to first understand if they really do know about our existence as an organization, so that they do know that there is such an organization that is in place which is meant to also address their privacy rights or their right to privacy as it relates to their protection of their personal information and our functions as well, so that they can be able to report or complaints to us whenever they feel like their right to privacy has been violated in one way or the other. And also I'm going to cover awareness of POPIA versus other information laws. We did compare POPIA with other information laws within the country to see as well in terms of the level of awareness, how POPIA compares to other information laws, also how we measure awareness and also knowledge in terms of POPIA, and also findings and recommendations, how we have then responded to them as an organization. Briefly, as I have indicated that, firstly, I'm going to talk to you just briefly about the background in terms of why we do what we do as an organization in terms of the public opinion surveys or research that we do. So in 2023-2024 financial year, we did undertake a public opinion survey, which was of national representative in nature, which means that we ensured that we visited all the 9 provinces that we have in South Africa. Of course, we didn't speak to everyone in realistic sense, but we sampled the sample that ensured that we have a representative sample which represents different demographics within South Africa, looking at the statistics from Statistics South Africa, taking into consideration all the demographic groups that we have in South Africa. And briefly, what we also just observed with 12 years of POPIA existence in South Africa, we still found that there's still very limited literature when it comes to just people writing in general about POPIA or just its awareness. So mostly what you find is that you find people who are writing about data privacy in other contexts, not in the South African context. So you're not able to really gather insights or thorough insights in terms of what is happening in the South African context. So what we normally do is that we compare with other countries then in terms of what is taking place in other countries, which sometimes it is a bit of a challenge because our context differ. We are in South Africa, yes, we have a data privacy, but we are specifically implementing POPIA. And in terms of the objectives for the particular studies, as I've indicated, that we aim to measure the levels of awareness around POPIA or around people's ability to be able to assert or be able to express their rights to privacy as it relates to the right to the protection of their personal information. And also what we aim to do is that then we aim to further take those findings and determine what can be done to further improve South Africans' levels of awareness and knowledge of POPIA, or also just about the existence of the regulator at large, and integrate those or incorporate those into our different awareness programs or initiatives that we have within the organization. And in terms of the methodological approach that we followed, I cannot, of course, speak to you about the findings or the recommendations from a study without really briefly reflecting on the methodological approach that we have followed. So briefly, we did obtain ethical clearance from an ethical committee for us to be able to proceed with the study. And as I've indicated, we also do have, we engaged in a thorough field work where we're able to then have a group of field workers. There was a questionnaire that was developed, a standard questionnaire that was developed to collect data, and we had a group of field work who were trained or thoroughly trained on the field on the questionnaire itself, and the questionnaire was also further translated into different South African languages to ensure that everyone had an equal chance of participating. And our field workers visited different provinces within South Africa and be able to engage people on the ground, not everyone on the ground, but ensuring that there is a representation representation of all the demographic groups within society on the ground for them to be able to participate and be able to also share their insights in terms of what they think about POPIA and also what they think about the information regulator and its responsibilities and functions. So they did engage in that process, also in the form of face-to-face interviews with people on the ground. A total sample that was achieved at the end, which was determined to be representation or fair representation of South African demographics, was a total of 2,112 adults or people or participants that participated around South Africa, taking into account the country's demographic characteristics that I have just referred to now. And as I've indicated then, when we engaged in this process, we don't just go on the ground and ask people about what they think, or maybe what they think about POPIA, but we started off by just asking them about their general awareness about the information regulator, about the existence of the information regulator, because whenever people do experience misuse of their personal information, we are a responsible body that is supposed to be the one that handles such complaints, where they are supposed to report such complaints to us so that we can be able to assist them and investigate them. So before they can be able to do that, they must know about our existence and also our functions as an organization. So we did first ask them about their knowledge about our existence as the information regulator. And what we found was that the majority of, the significant minority of our participants, which was like 30% of the 3,112 sample that I referred to, indicated that they have neither had a lot or quite a bit about the information regulator. So those are the people that indicated that they have had at least, maybe they've had a mention of the information regulator in passing, or others do actually know the full responsibilities or functions of the organization, but others have just had a name of the information or existence of the regulator. And approximately 70% of those knew nothing about the existence of the regulator. So those are the people whom, whenever they do experience personal information misuse or violation of their right to privacy, they wouldn't even know who to report to because they do not know about our existence as an organization or as an information regulator. And what we found, interesting enough, what we found amongst those groups is that awareness of the regulator was found to be high on average among racial minorities, tertiary educated people that participated, and also people who are employed and better off citizens. So that means that somehow already portrays us as an elite organization that only serves people who are placed in different, who are already at an advantage within society, while also we are not able, or we are not really being known amongst people who are marginalized and also disadvantaged people. And when it comes to the knowledge about the regulator's functions specifically, so that those particular findings, actually they do mirror general awareness of the existence of the regulator, because once you know about the regulator, yes, there are people who know about the existence of the regulator, but they do not know the functions in terms of what we're responsible for. But when it comes to that particular question, it meant that the findings or the recommendations that we get from that are going to be limited only to those who actually know about the existence of the regulator, because it was already limited to the 30% that indicated to know something about the existence of the regulator. As we indicate there, that by virtue of not knowing about the existence of the information regulator, the majority did not know about our functions or our responsibilities as an organization. And also similarly to the above finding in terms of the general awareness about the existence of the regulator, the roles and responsibilities was higher, the knowledge about the roles and responsibilities was higher amongst people who were tertiary educated, employed, or financially better off within society. And moving straight into just now awareness of POPIA versus other information laws. We did compare POPIA with other existing information laws within the country, such as PIA, and also RICA and also ACT, just to see how it compares to other information laws as well. When we compare to it, just knowledge about POPIA, existence of POPIA specifically, we found that only a third of the participants or people that participated indicated that they are aware of POPIA. Those are the people who are probably just aware, or they've had a mention of POPIA, or sometimes when we do have interviews on radio on specific matters, they do hear the name POPIA POPIA being thrown around quite a lot in the radio, or other people actually do know about in detail in terms of what POPIA stands for. So it was only 33% of those people who participated indicated that they are aware of the existence of POPIA. You see, when I get to the actual rights, some of the rights that are entailed in POPIA in terms of awareness, you see the differences there in terms of people being aware and actually also being able to assert those rights whenever they are confronted with a situation, to be able to assert those rights. And this was higher than all the other information laws within the country. So that was higher amongst like POPIA, ACTA, and also RICA. You'll see, I do have a graph in the following slide that just shows in terms of comparison between those information laws that we have compared with. It was higher amongst those other information laws, but I wouldn't say that it was high enough, because we are just here just looking at POPIA specifically. And in terms of awareness of POPIA, it was lowest amongst those living in rural areas and those with secondary education, and also without secondary education, and also amongst those older people or elderly persons. And that is also another reason why, as a regulator, when we design our public awareness programs or outreach programs as well, we ensure that we target people, specifically marginalized people who are located in those areas, either rural areas, townships, or people who are located or who have no tertiary education, or older persons, to be able to educate them, because we do not want to leave those people behind as well. And as much as we're talking about systems that need to be put in place to ensure that there's compliance with POPIA, but we don't want to leave the other people behind, or those people, marginalized people behind, in terms of them just being aware of POPIA, or being able to assert and articulate their right to privacy as well. And when we further inquired in terms of what seems to be the challenge for people to be able to understand or know about the existence of POPIA, articulate their rights as entailed in POPIA, what emerged mostly was the fact that language was one of the main barriers for people to be able to understand and articulate or assert their rights. And in terms of the language, it is just the technical language that is being used in the legislation for someone who has no formal education, who is in the rural areas, an older person in the rural areas, being able to understand what is originally articulated in POPIA, which is the reason why from all the time when we engage with the members of the public, we ensure that we further translate our material that we are using to communicate and engage with the public when we raise public awareness, so that we translate it into a simpler language, simpler terms that people are able to understand and be able to articulate their rights whenever there is a need for them to do so. And when it came to just awareness of important rights, some of the rights that we picked from POPIA as well, which was one of them was the right to consent for one's personal information to be processed, and also another one was to be notified when their personal information is processed, and also their right to report to the information regulator whenever they experience personal information misuse. The rights that seem to be less popular was the right to object whenever whenever people do not want their personal information to be processed by a responsible party. There was one that seemed to be less popular in terms of the other rights when you compare with the other rights, and also the right to be notified when personal information is processed or is used in any other way seemed to be a bit popular. But just looking overall in terms of all these rights, people being aware and being able to assert these rights, there was just a general lack of awareness of POPIA rights amongst all the participants that we have engaged with when it comes to them actually having to articulate and actually express and assert their rights. And this is just a graph that I referred to where we had compared with other information laws within the country. It was, the first one was the Promotion of Access to Information Act, which is still the same act or legislation that is, that lies within, which is still the responsibility of the information regulator. And the second one, POPIA, and then RICA, ACTA. So if you look at those four information laws that we had compared with, POPIA seemed to be one that was most popular in terms of people just being aware of its awareness. And in terms of how we had measured awareness and also knowledge. So the factors or variables that we looked at in terms of us measuring awareness, knowledge, and people being able to assert their rights. So one thing that we looked at was the efforts that people put in protecting their personal information. So specifically, we looked at people's ability to read terms and conditions, because we had to look at something that we think that almost every individual can be subjected to in one way or the other. I think most people are subjected to just having to read terms and conditions, whether you're signing a contract in a shop, whether you are signing something, accepting something online, or whether it's an old person trying to take up a cell phone contract in the rural areas, they are subjected to, in one way or the other, read terms and conditions and also expected to read. So that was one of the variables that we looked at, which was their ability to, the effort that they put in protecting their personal information. Even though the majority agreed that they make an effort to protect their personal information, but when it came specifically to reading terms and conditions before accepting them, we found that only 19% indicated to always read the terms and conditions before agreeing to them, reading them and understanding them, also understanding the implications that are around those before accepting them. Only 19% indicated that they actually do read the terms and conditions. And we found that there was a positive correlation between reading terms and conditions and also education attainment. So people who indicated to have tertiary education, obtain tertiary education or have a tertiary education qualification are the ones who mostly indicated that they always make sure that they do read terms and conditions to understand some of the personal protection of their personal information implications that could be involved. Another variable or factor that we looked at as well was the experience of personal information misuse and also recourse that one has to follow whenever they experience or whenever their personal information is being misused or their right to privacy is being violated. And what we found was that when overall looking at the total sample, concern about information misuse was more common amongst people who are better educated or middle-aged and also urban dwellers. So those are the people who expressed that they actually are very much concerned about the potential possibility of their personal information being misused in different instances. And also another variable that we looked at measuring awareness or knowledge, we also looked at the likelihood of reporting personal information misuse to the information regulator. Already that was mostly limited to people who indicated that they are aware of our existence as an organization, as an information regulator or a data protection authority within the country. So just over half of our participants indicated that they would approach the information regulator to register a complaint or report a complaint whenever they do experience personal information misuse from time to time. However, what was more concerning for us was the fact that the majority of those people indicated that the regulator wouldn't be the body that they would approach whenever their personal information is misused. This is simply because people do not know about our existence or they do not know of our functions, which means that we still have more to do in educating people about our existence, about our functions, so that they can be able to report those, direct them to the right body. Instead of coming to us, people would identify that they would rather go to SAPS, which is the South African Police Service, to report such, which means that they do know that a law in one way or the other was broken, but they don't know the relevant body that they're supposed to report to. Or others would say that they would rather go to the bank if ever their personal information was misused in the context of maybe their banking details or whatever the case may be. So those are one of the things that we have also just noticed or noted in terms of these findings and recommendations, and also just means that we still have more to do as well as an organization to ensure that we educate people. And as far as the program director was indicating that we now need to look at the systems that organizations need to put in place to ensure that there's compliance, but we also need to make sure that we don't leave the other people behind, because there are people who simply just don't know about the fact that they have a right to privacy. They don't know about our existence. So we need to bring those people along as well, because they are the same systems that we need to put in place for compliance. They are being affected by those, and they don't even know that they do have a right. So those are some of the things and insights. And I must indicate that there's more to the findings that we found and recommendations. Just this is a summary of the things that we were able to lift up for this particular session. So just specifically looking at the findings and recommendations, I've already referred to the findings as I was just presenting now in terms of what the analysis, but just briefly zooming into those. So the first one that we have discussed already is the awareness of the regulator and its responsibility and functions, which was relatively poor when we assessed. So how then the recommendation that was linked to such a finding was that we need to heighten our communication, awareness, and education programs as well, that we need to design them for people to be made aware and more aware of the mandate of the regulator, especially its dispute resolution and also adjudicatory roles as a data protection authority within the country. And we need to specifically focus those amongst the population groups that we've identified to have low stocks of knowledge just about the existence of the information regulator. And those are the things that we are doing, as I've indicated, that we have really thoroughly engaged with these findings within the organization, just to determine how we can incorporate them into our awareness program. So we have been doing that since this was concluded in 2024. We have been doing that in ensuring that we incorporate these findings and insights into our programs so that we respond to the needs of the people on the ground. And the second finding was that the stocks of relevant knowledge about POPIA specifically was also low. And the recommendation which was linked to that was that we need to intensify efforts in promoting public awareness of POPIA, right to privacy, and also associated rights, and also avenues of recourse, because we also determine the fact that, or notice the fact that people were not aware in terms of the avenues of recourse that are available for them whenever they experience personal information misuse from time to time. So we need to further intensify efforts in ensuring that we incorporate these into our different initiatives or public outreach initiatives, and also focus on, in terms of those demographic groups, focus to those demographic groups that we've identified to have low stocks of knowledge about POPIA, such as people who are located in rural communities and also other subgroups that we have identified. And interestingly, one thing that we found, because we've also asked people in terms of how do they prefer to be further educated about their right to privacy, and the majority of them indicated that they would prefer to be educated through traditional media, which is through television or radio, television or radio adverts. And that's one of the recommendations. Even though we have been implementing it as an organization through the usage of community radio stations, but there is still a greater need for us to be able to respond to this particular finding. But because of the budget implications that is associated with it, we haven't really been able to fully implement it and ensure that we are able to educate people through traditional media, as they have indicated that they would like to be educated through such a platform around their right to privacy. And the third finding was a significant proportion of the participants would not approach the information regulator to report a complaint, or whenever they experience personal information misuse. And the recommendation that was linked to that, we need to have relevant mechanisms and outreach programs, campaigns to encourage people to report violation of their personal information. And if we have also, the fourth one was also the fact that language emerged as a barrier to understanding POPIA, or what is their right to privacy as entailed in POPIA, which is why we have really translated a lot of our public awareness programs and also the initiatives that we use, and translated the material that we use to communicate with the members of the public to sort of like read what is entailed in POPIA, but further translate it for someone who's like for someone who's maybe located in the rural areas, for them to be able to understand and be able to articulate their right to privacy whenever they are confronted with a situation, to actually do articulate and assert their right to privacy, because we have determined the fact that language also did emerge as a barrier for them to understand. Also, the fifth one was the need to targeted approach to reach the youth. So we also just specifically looked at that in terms of how we can further respond to the needs of the youth, as well as they are the ones who are they have much presence in terms of digital platforms as well, and they have a lot of their personal information exposed in such platforms. So we wanted to understand further how we can be able to meet their needs and also be able to educate them about their right to privacy and all the risks that are associated with that. And the recommendation was that we need to make greater use of modern ways of reaching out to the people of digital platforms, raising awareness at schools, universities, and colleges, which is what we've been also doing in terms of raising awareness awareness in terms of our digital platforms that we have as an organization, and also raising awareness, visiting schools, universities, and colleges. Of course, it might not be that visible maybe to other people, but it's something that we are doing, and we are really trying to intensify our efforts in ensuring that we respond to these particular recommendations. There are others as well in terms of the findings and recommendations. There were about 13, and we have really thoroughly engaged them and ensured that we respond to them as an organization. And just lastly, in terms of then why we do what we do as well, is because we want to contribute into our impact statement as an organization, which is all persons, we want to see all persons empowered to assert their right to privacy as it relates to their protection of their personal information and also their right of access to information. So this particular project, which is the public opinion survey, is also just aimed at ensuring that we contribute towards that impact statement as an organization. We want to do it from an informed perspective, which is informed by the findings that we generate from these public opinion surveys. Of course, there are other means as well that we utilize as an organization, but this is one of the ways that we aim to contribute towards that and ensure that we respond to the needs of the people on the ground when it comes to their right to privacy and actually being able to assert their right to privacy. I would like to thank you, Program Director. I know I took more than what was allocated to me, but it was impossible for me to speak within 10 minutes about such interesting topic. Thank you. Okay.
Perfect. Thank you very much, Ms. Shilembe. I think what many of us will agree is that it's a powerful reminder and a thorough reminder of how data protection is experienced beyond institutional walls and that no one should be left behind. Are there any questions from anyone in the audience? And while anyone is thinking, I have a basic question, and that's whether the research will be available to the public that you've conducted, or the presentation that you've made, whether it will be shared.
Yes, it is for consumption by the members of the public because we actually, as I indicated, that we did obtain ethical clearance from an ethical committee, so it is available for consumption by the members of the public.
Any questions from the audience? Perfect. I think the mic is just behind you. Yeah.
Thank you. Good morning, everyone. My question to Ms. Shilembe, thank you very much for your presentation. Now that you have done the survey and came up with your report, what's next? What are you going to do now, especially for the rural areas in terms of the awareness? How are you going to address those awareness shortfalls? Thank you.
Okay, thank you so much for the question. But as I've indicated that also the fact that we have concluded the public opinion survey in 2024, it's not the end of the road. So when we get the findings and the recommendation as an organization, we sit down and thoroughly engage them and determine how can we better engage, incorporate them into different public awareness programs that we have as an organization. So in terms of targeting specifically rural areas, we do have a program within the organization that we call Tikopano. We take the regulator to the people. We specifically target people who are located in rural areas or remote areas rather, where we take the regulators to the people and further translate what POPIA means for them, what the right to privacy means for them. Of course, it's not as far-reaching as we would like it to be as an organization, because we are able, thus far we've been able to at least visit 2 communities, rural communities in a year or in a financial year, which is limited, but we also do have other means of public awareness as well, where we go visit different malls as well, or just busy intersections within communities, where we educate people and raise awareness around POPIA and people's right to privacy. So if you haven't seen us within your community, community, your turn is coming, we are still coming, we are responding to all this. And also we do this on periodic basis because, I mean, the public opinion surveys themselves, because findings and insights differ from time to time. So we're just giving this time so that you can be able to implement, but you still revisit the field again just to check how do people feel about POPIA, like what are the levels of awareness thus far. So we do it on periodic basis as well. Yeah.
Thanks so much. Are there any other questions? Okay, please go ahead.
Am I audible?
Yes.
Okay. Yeah, I just had a question, and thank you so much for the information. I think it's quite meaningful, especially coming from the private sector as well. My question was, were you able to also juxtapose some of the findings with the digital literacy rates, and to think through some of maybe the drivers as well from a digital literacy or a data literacy perspective versus then what you found about the knowledge of people and awareness of data privacy and data protection, or even the information regulator itself?
So, of course, when we initiated the survey itself, we were already, we've determined that as well already from just reviewing the literature in terms of digital literacy levels within South Africa, which are quite low, which is the reason why also we do not want to focus our awareness programs just raising awareness on digital platforms, because we do take into consideration the fact that digital literacy levels are quite low within South Africa. We have determined that when we did determine that when we reviewed the literature. So, and also when we look at the findings themselves, we keep on improving in terms of the questionnaire, because when we develop the questionnaire, even for the next installation of the public opinion survey, we look at the findings and also just re-look at the questions that we have, and so that they can be able to mirror the realities of South African communities. So we have already, we determined that through the literature review, but we did not really specifically target that particular aspect when we were installing that particular round of the survey. But it's something that we also just look at as we implement the surveys moving forward.
Perfect, thank you so much. I don't see any other questions. What we'd like, well, thank you very much, Ms. Shalambe. In our next session, we'll be looking at our first panel, which will be focusing on why privacy matters. The panel asks a foundational question. Not whether privacy matters in theory or in law, but why it continues to matter in practice, particularly in complex social and organizational environments. I'd like to ask the moderator, Mukelani Dimba, to join me on stage and introduce the panel.
Just use, I can speak from here as well. Good morning, everybody. Okay, I'm going to try again. Good morning, everybody. My name is Mukelani Dimba. I'm the acting executive responsible for the Promotion of Access to Information Act. At the Information Regulator, I've been given a singular honor to moderate this next panel. This panel is going to really be a starter. If this conference was a meal, this panel is going to be a starter course. We are going to explore key themes that are going to be discussed during the course of this conference. So the panelists that have been invited to participate in this panel are going to really lead the discussion for the rest that is going to take place in the rest of the day. We want to explore how far we've come and how much further we are still to go with the right to data privacy. And so we have asked a group of very knowledgeable colleagues on the aspects of the right to privacy as it relates to the protection of personal information. So in this panel, we will have Advocate Tsepo Buikanyo, who is the executive responsible for POPIA at the Information Regulator. Advocate Buikanyo, please come forward, and can we please give him a round of applause as he approaches. We are also going to hear from Ms. Amanda Macheta, who is the executive responsible for data privacy and protection at First Rand Bank. And they'll be joined by Dr. Charlene Cruiser, who is the attorney and is at the Legal Resources Center. Thank you very much all for making the time and for agreeing to assist us to set the tone for the rest of this conference. Maybe let me start with the personnel. I think I have to join you there, right, Nathan? To walk across? You see, I wasn't properly trained how to do this. I hope this works. Testing, testing. Can you hear me? It works? Okay, brilliant. So what I would like the panel to do for us that are attending this conference today is to really start with the personal, then move to the more macro issues around data privacy, and also, as we conclude, to think forward, to think about the future. What next? What else is going to happen within this space? So let me start with the personal, starting with you, Charlene. How has POPIA changed your life?
Wow, that is actually quite a big question. I'm just going to adjust my mic a little bit because I feel it's very close to my mouth. Okay. I'm going to use an example because I think that's the best example I can use. We were recently in the very fortunate position to buy a house. And of course, as part of that, you sign so many forms, whether it's with banks, the bank's attorneys, the estate agent, the seller's attorneys, and as part of signing those forms, you also have to consent to the processing of your personal information. And some of that makes sense because, of course, there's some compliance that needs to happen in the background. And although I understand that causation and correlation are not the same thing, in the last year, I can't even count to you the number of direct WhatsApp messages I have received from estate agents, which I never consented to receiving, but somewhere along the line of signing a form to an estate agent or a bank or an attorney, this information, the consent that I gave was apparently sufficient for this information to be passed on. That's a very minor example. I can then speak on a more personal level. Something that I'm quite interested in and that I want to speak about more is how POPIA impacts the processing of personal information in relation to elections. So during the 2024 elections, we saw a lot of campaigning by political parties, especially on Facebook. And we actually did a study on this at the Legal Resources Center with some data scientists because I have no business processing data. I don't understand it. But what was very interesting was when we started looking at what political parties did and how they identified who to advertise to. So for example, I am a white woman in my early 30s. I live in Cape Town. I am well educated and I engage with the municipality's pages on Facebook and I like a few Sandparks pages. I received messages or advertising directed to me to vote for the Democratic Alliance because they could identify based on the personal information that I have on Facebook that I am the candidate or I am someone that they want to have vote for them. And that's a broader issue that I do think that we're going to have to start dealing with in POPIA and in the information regulators' work as to the extent to which we allow this type of processing, and especially because it's on like a social media site, right? Like to sign up to Facebook or to use WhatsApp, you essentially tell them you can use my personal information, but it's not real consent because you kind of need to use WhatsApp in South Africa. It's the cheapest way to communicate. So I think those are like two examples of what POPIA has done for me, is that where there are instances where I feel like my personal information was shared and I'm being contacted where I know that I shouldn't be, it's been fairly easy to very clearly communicate to people holding my information that this is not okay. And I feel like that's something that I've been empowered to do by POPIA. But on the other hand, with Facebook, Meta, social media platforms, I mean, I don't matter. What am I supposed to do? I can't show that there's a harm in being advertised to. Yeah, so that's on the personal level.
On the issue of political parties campaigning
Yes.
Electronically, has this been studied systematically to look at the trends over the years? Because I do remember that was it the 2019 elections and the 2021 local government elections, there was a lot of that happening.
Yes.
Political parties bombarding voters with campaign material. In 2024, do we get a sense? Because in the meantime, the regulator issued a guidance note.
Yes.
So in 2024, did we get a sense of it reducing that practice, or it pretty much has remained the same?
So
Has anybody done a study on this?
So we did the study in 2024, but we only looked at Facebook and the Meta ad library because, I mean, we're an NGO, so we didn't really have the resources to go into every single social media site, and the Meta ad library was quite easy to work with. So we had a data scientist looking at that information, and I think what we could definitely see was that the advertising was less misinformation driven. It was more around general themes. So themes that we saw, I mean, firstly, we saw the Democratic Alliance, unsurprisingly, spent the most on political advertising. They also ran the most ads. But then what was actually more interesting when we looked at the types of themes that emerged is it was similar across political parties. Across political parties, they say, get out to vote. We need to address corruption. Employment is an issue, infrastructure, education. But I think if you then look even more granularly, what was very interesting to me is the types of groups that they targeted and the location. So, of course, we can't say that the advertising had any real impact because we don't know. We don't know how to test that. The elections were free and fair, declared to be free and fair. But what was interesting was the fact that we could see that voters in Gauteng and Western Cape were mostly targeted. You also had men being targeted more than women, and then the age group being targeted primarily 30 to 39 years old. So I think that also tells us who are the people on Facebook. But I think what I'd be more interested in for these next elections and for the national elections coming up later on is how we might see this playing out on WhatsApp, because WhatsApp, of course, is the major social media site in South Africa. Facebook, I'm not really sure. Yeah, but that's, yeah.
Interesting. Yeah. Thank you. Ms. Maketa, how has POPIA changed your life?
Just while we're on that, Mr. Dimba, I've been receiving a number of messages of people saying, please correct your personal information. You are Mrs. Maketa Sebake. Just that data accuracy while we're on the data quality conversations as well.
Congratulations.
And I think just also to disclaim that I am speaking in my personal capacity, and any of my views and opinions are that of my own and not of the financial institution that I work for. T's and C's apply. So I think from a personal front, I mean, as you can hear even in my dialect, it's changed my entire life, right? It's also given me an entire career, advocate. So for a lot of, whether it's lawyers, compliance officers, risk managers as well, POPIA has actually opened up opportunity for a new type of career altogether. We are seeing that also happening now with the AI coming into play and new job opportunities that are coming out as a result of that. It's not something that one would anticipate would be the answer if you say, how has POPIA changed your life? Because on a personal front, you look at how you experience everyday life. Are the organizations that you engage on a day-to-day basis actually applying the POPIA principles that we expect them to apply? But if I say on a personal note, it's actually provided a career opportunity that has changed the trajectory of how I envisaged my career would take root. And in an economy where there's so much unemployment, where we are seeing students in university not knowing what to study, not knowing what direction to take, insofar as some of the the well-known bachelor's degrees and diplomas, etc., this has actually created an opportunity for more jobs. It's created an opportunity for a completely different career path that didn't exist 10 years ago, 12 years ago, in this country in particular. It's created the same opportunities internationally, of course, but I'm talking to our current employment status. So outside of that, just to carry on the conversation that Jolene was having, I think prior to POPIA even coming into effect, I was private by design. And I say that because when Ms. Chilemba was talking to the 18% that read, the 19% that read the T's and C's, terms and conditions, and the policy statements, by virtue of being a lawyer by background, I was reading anything that I'm contracting with. And I found now, unlike before, that people are more receptive to you having the conversation around protection of personal information and privacy as before, where you'd say, I need some time to read these T's and C's. It would be just sign here, here, here. Now when you say, I'd like to actually read these T's and C's, and actually when you get contracts, you're entering into a relationship of sorts with a service provider, they now even give you an entire form that is their POPIA form, right? Which wasn't the case before. And naturally, I read those, I vet, I review, I correct. But what it shows is that it's even changing the culture within the country and how we actually engage with personal information and people's information. It's giving people options. Let me say it's giving me options because you asked a personal question. Because ordinarily, if you're going to for a service, you require a particular product, it's take it or leave it. But now organizations know they can't have that type of attitude when it comes to your personal information, and they know they have a responsibility to actually inform you as to why they're collecting whatever information they would be collecting and for what purpose they're collecting that information for. So it's changing the culture of how we do things. It's also causing us to respect each other and to understand that my personal information is just that. As an institution, if you've collected this information for whatever purpose, it doesn't then become your information. It still remains my information, and I have the right to control what you do with it. I have the right to know what you're doing with it, and I have the right to, at some point, say, I would like you to stop using my personal information. So that's how it's changed my personal life.
Wow, thank you.
Thanks.
And I would like us to, at some point, come back to this issue around privacy by design, because it's one of those big themes that we need to, grapple with and really try and establish understanding as to what do we actually mean by when we talk about privacy by design. But we'll come back to you on that one. I worry about asking Advocate Buikanyo the same question. How has POPIA changed your life? I'm concerned about your answer, but let me give you a chance.
Well, a lot of what the colleagues have said resonates with my experience, but I just want to say that about 3 years and a couple of months ago, I came into the information regulator, and I remember the interview that I had, and the chairperson was on the panel together with the members. And one of the questions that they asked me was, do you know the amount of work that you have to go through in dealing with POPIA? And I was under no illusion of what really lies in front of me. Fast forward, I am appointed, and And we have to start with these assessments now. And I can safely say that we've come a long way as a regulator. I look at the room and I say a lot of the colleagues that are in here, at some point or the other, we've interacted with the colleagues, including the colleague that is next to me here, and through an assessment, So we've come a long way. There were quite a number of things that we had to figure out together with the members, the interpretation of POPIA. There was no jurisprudence to guide us, and we had to figure out certain things. I had to put together a team, and quite a formidable team. Those that we have assessed will tell you, over the period that we assess them, we have a team, and the questions that they ask, they probe, and we have really improved as the division, as POPIA, as a division, and equally, the members have come, having interacted with this piece of legislation, they've got a better understanding of this piece of legislation. I would get into a session with the members, and the members would say, but back in the days, this is what we used to do, but we are now wiser as the members. And I think that we are growing in leaps and bounds as a regulator. There are certain things that we are picking up. The cases, the complaints that are coming to us and the assessments are getting more complex. They're getting more technical in nature. And what does not help is that when you have corporates like the ones that we have that constantly see us as a fertile ground for whisking away our staff members to greener pastures, it does not help us. It does not help us. But we've grown as a regulator, and I think that we are really a formidable regulator. When we go out, even when we go out to other countries, the work that we've done is really recognized. And the number of the colleagues here in the room have invited us to their premises for us to go and share our experiences, for us to go and assist them with regard to how POPIA is interpreted, and we've come a long way.
You speak, Advocate Buikanyo, about this process of evolution. Yeah. The environment has evolved over the years. Practice has also evolved. I'm sure there are certain lessons that have been picked up along the way that say, this is where the challenges are, and this is what needs to be done to strengthen the legislation or to strengthen an institution such as the Information Regulator. Can you share some thoughts on that? No,
indeed. And one of them, when the chairperson was addressing us here, she made mention of AI. The rapid technological changes or advancement would be, for me, an immediate issue. Our laws, our POPIA, sometimes in certain areas, we feel that does not sufficiently address what we wanted to address. And we also have complex ecosystems that make investigations very complex and demanding. But further to this, we also have low levels of compliance and awareness. Data subjects are often not aware of their rights. We have many organizations that treat POPIA just as a tick box. And we also have lack of training and awareness by responsible parties. But also further to this, the issues of jurisdiction and cross-border transfer of personal information. In one of the sessions that we had with the members, Advocate Lakula made mention of the fact that personal information is often stored outside the country. So that creates a problem, because when personal information is stored outside the country and is processed outside the borders of South Africa, this complicates issues relating to enforcement and data privacy laws. So this is a real issue that we have to grapple with. And we don't often have cooperation with other regulators outside South Africa, and that makes our life a bit difficult. But also, the other challenge that I can highlight would be resistance from responsible parties. Now, we all know, as we're sitting here, that we've assessed state departments. We've assessed the Department of Justice. We've assessed, as an example, the Department of Basic Education and other large corporations. And they resist enforcement of POPIA. We often get, I was just talking to the team just the other day, and we have a complaint of Truecaller. And one of the issues that is being raised there is the issue of jurisdiction. So we often have these issues where those sort of issues like jurisdiction are being raised, and there are legal challenges. We've issued enforcement notices, and I'm sure everybody would know that we've issued enforcement notices in relation to the Department of Basic Education and the Department of Justice, and they've taken us to court. Now, this is one of the issues that we have to sit and we have to grapple with. And from a policy positions, we have to defend our territory and litigate. And then the issue of limited jurisprudence is not something that I can forget. There's a lack of case law that helps us as a regulator in dealing with these cases or these matters that come before us. We recently had the DBE judgment, and this is something that we are appealing because we feel that we don't agree essentially with the judgment. So those are some of the things that just off the top of my head that I can highlight as the challenges that we have from a regulatory perspective if we was to approach this issue from a regulatory perspective.
Okay, all right. Mrs. Amanda Maketa Sebaki, your constituency is resisting compliance efforts. This is what Advocate Buikanyo is saying. Can you share some thoughts from your side as to what are the challenges that are encountered and maybe possible solutions?
So, I think normally when people don't understand what is required of them, or when something is confusing or challenging, you then would be met with resistance, right? And I think with POPIA, although, and Ms. Chalemba was showing her stats there, it's well known, so people know about POPIA, but there wasn't a question around how many people have actually read it, and how many people have actually understood what it requires, and how it applies to their everyday operations. And that includes organizations as well. Organizations were to a large degree left to their own to fully unpack POPIA, understand what it means. Is it a compliance exercise where we're ticking a box to say, okay, we've got this in place, we've got this in place, but is it actually effective? Is it actually satisfying the purpose for which it was designed to satisfy? Is it showing that you respect information and that you're only processing information in a reasonable manner? So I think at the core of it is the need for better awareness around what POPIA actually means. What does it mean for you as a telecommunications company? And what does it mean to your ordinary way of doing business? Does it impact your ordinary way of doing business? Or if you have a policy in place, you're 50% there, so that's as far as our risk appetite goes, we're good. As long as we've got 50%, we're not trying to be A students here, and we keep it moving, we have other priorities. Similarly to how, I think it was Chairperson who was in her opening address, was talking around some of the constraints in respect of ensuring that POPIA is as impactful across the country as it should be. The Information Regulator Office has challenges as a company, right? Where you need resources, you need to be innovative around how you're communicating around POPIA. Are you reaching the right audience? Are you reaching the right audience at the right level? Are you speaking their language? Do they understand in their own language what you are actually talking about when you talk about purpose specification, for example? The same goes for organizations that are going about the business of doing business, trying to be profitable. And now here's this daunting legislation. It's quite a daunting legislation. I mean, we saw even with the GDPR, which almost instilled the fear of God in organizations to say, oi, look at how that commissioner is operating in Europe. This is coming here, so you better put everything in place. And a lot of resources were then thrown into ensuring POPIA compliance and adhering to POPIA, legal opinions from advocates and law firms to say, how do we actually, what does this mean? What is an authorized person? What is a legitimate interest assessment? What is, when we say consent, what does that really mean? Because I know consent to be, do you mind if I do this? And you say yes. Now we're saying it must be specific, it must be voluntary, you know, it must be informed. So there's all these T's and C's within some of the principles that then add on to the need for people to know and understand privacy more, and where they can't because, well, this is not my day job, it's my day job, this is not my day job, I have other things to do, I will stay in my state of confusion, and what you are then met with when you're trying to enforce is, I don't understand this, so I resist it. So I think there's a lot of work that needs to be done around assisting, and I mean, you are a team of how many in a country of 60 million odd people. But there's a lot of expectations from both the community, public sector, and private sector to say, regulator, help us, help us understand. So we all want to be tutored, and we want personal tutoring. We don't want a guidance note that also needs us to now get a legal opinion to interpret what does it actually mean in reality in our particular type of industry. So there are challenges, but I think they can be overcome. They won't be overcome overnight. And 4 years of enforcement in a country with so many large multinational organizations is actually as long as a day, if we think about it.
Maybe if I can weigh in here, Amanda has raised something, and I think I must just comment on it. I think from a regulatory perspective, we also acknowledge that there can be better guidance that is given in relation to certain things. We have Regulation 4, for instance, it talks about your PIA, your personal information impact assessment. We have not prescribed as a regulator as to how responsible parties should go out and conduct a PIA. And those are some of the things that we've picked up and that we're working on. You know, in the next coming financial year, that is something that we're flagging, and we feel that responsible parties must be given better guidance. I think, Mr. Dimba, your team in EduCom, when they go out and they provide training, one of the questions that they also get asked is, but how do you conduct this PIA? And when we also conduct assessment, that's one of the issues that come out to say, but you've said in the regulations that we've got to conduct a PIA, but how do we go about conducting this PIA? Is there a format? So everybody has got their own, every responsible party has got its own understanding of what constitutes a PIA. And that's some of the areas as we go along that we're picking up and that we'll continue to improve on.
Let me give Dr. Cruiser a chance to weigh in on this point. I mean, it's 10 years of the regulator having been established, 13 years of having a PIA being enacted by Parliament, more than almost 5 years now of some of the provisions of POPIA coming into force. Did I say PIA? I meant to say POPIA. What are you hearing from these two stakeholder groupings? The regulator on one hand, and of course the private sector, but you sit outside that space. What are you seeing? Where are the high points? Where are the low points?
Well, I think you both work at a very granular level, it seems, and it's about firstly understanding the provisions of POPIA, but then also how it applies in practice. I think it's hard for me to comment on that because I work in a human rights space. So how I look at processing information is from a human rights space and whether it protects us as data subjects. And when I listen to how we speak about data processing and the challenges, is that it sounds as if data processing is often very neutral or technical. But I think we should also be aware of the reality that data protection or the failure to protect certain types of data shapes power and autonomy and how we participate in society. And I mean, again, I can speak for hours about the political aspect of it because that's something that I've been very interested in. But perhaps I can move a bit away from that discussion into the political space again and just sort of my concerns with what I'm seeing and where we're going, potentially. So, I mean, I want to go back to just the basics of how we see personal information, right? I mean, I'm not going to read a definition, but very broadly, it's any information that relates to an identifiable, living, natural person. And all of these things like race and gender and political persuasion and all of those things go to the heart of belonging and dignity and personhood. So when we speak of POPIA, I don't want us to, or I think we need to be cognizant of the fact that we are dealing with not just a technical level, but we're dealing with people every day and the impact that data processing can have on them, and not necessarily just in the sense of, my estate agent sending, other estate agents sending me information, but how what we perceive as consent to services like WhatsApp or Facebook, like whether that is actual consent. Like, is consent to data processing meaningful and sincere, informed, free, and meaningful if you don't really have a choice in consenting to use that service? Is it then reasonable to say, okay, but then if you don't want to consent to this data processing and for how we use your information as this company who holds your information potentially outside South Africa, then you shouldn't use our service. But then we are holding South African companies to account, but we are not necessarily doing the same for global companies with lots of money. And I think that's something that we are going to have to start grappling with, and not just looking local. I know there's been enforcement notices to WhatsApp. I know there's been like settlement there. But I think from a public education perspective as well, it would be very useful for us as a public to also understand what, not necessarily the contents of that, but just what were the issues, etc. But I got sidetracked there a little bit. But the last thing that I want to say is that I've thought a lot about processing personal information in general in the context of elections, and how far the prohibition of processing personal information based on various personal characteristics really go, if there's always an exception that if you've consented elsewhere, then it's fine to process the information. And again, it's not about knowing exactly what's done with your information all of the time. I mean, that's impossible and unreasonable. But it's, to me, about something a bit more intangible. So how data processing affects political participation, how it affects freedom of religion, freedom of belief, how it affects hate speech, disinformation, misinformation. And for me, in the absence of robust regulation of large tech and social media companies, which is where the intersection between data processing and human rights often lie at a large scale, the tensions become quite hard to navigate. And yeah, that's my core concern, whether what looks like authentically held beliefs are actually authentically held beliefs, or whether it's increasingly the product of designed informational environments, which I think is a complete sidetrack from, how businesses comply with POPIA. But I think, I'm very concerned about the potential impact on us as individual users. And I think the role of POPIA and the information regulator is going to become increasingly important. I think, that the information regulator's note on how to deal with data processing in the context of elections was an incredibly important starting point. But I think we're going to see new ways of, or perhaps increasingly, how data is being used during elections for various other reasons.
Thank you. I do have more questions, but I think the audience may have better questions than me. So let me open it up to all of you to make input, interventions, ask questions of the panel. This is an opportunity for that. I'll pose my own questions for now. Let's see, by show of hands, please say your name, the institution you're affiliated with, and then make the intervention. Yes, ma'am. And please indicate who the question is for, if it's a question.
Thank you. Thank you so much. I'm Tandiwe, and I am from the IDC. Just a question for Advocate Bukanyo. Certainly, we're struggling with interpretation and subsequently correct implementation. And my question is, what does it look like then when you come through to do an assessment? So you, for example, and then specifically on the PIIA, that we're struggling to sort of find what we need to do, how do we implement it, how do we make sure that it is correct templates that we're using, etc. So what does that look like when you come through to our organization and then you come and assess us and you find that we got it wrong? You know, we misinterpreted what was required of us. If you can assist me with that, thank you.
It sounds like you are asking for the exam paper before the exams.
No harm in that.
Let's Advocate Buikanyo, a response, and then I'll go back to the floor.
Yeah, maybe as my starting point, I need to say the following, that, and this is something that I always say to the team, that, you know, POPIA is one of the friendliest piece of legislation you can ever get. It's friendly from this perspective, and I've said this to our colleagues, you know, during assessments. It's friendly from this perspective that it affords you the opportunity of going to correct before we come out and we issue enforcement notices. So if you have attempted to do a PIA and you have not fully complied with what our legislation provides for in your conducting of a PIA, but a PIA is essentially an audit of the personal information that you process. What is it that you process? How do you process it? You know, so if you haven't done that, and we find that you've missed you're off the mark with regard to your conducting of a PIA, then we will afford you the opportunity of going out. Even in the enforcement notice that we draft, we will say to you, you have 3 months within which to go and do this, and only in instances where you have not done that would we then come back and issue an infringement notice. So it's in that context where that I say it's a very friendly piece of legislation. Well, we want to move away from this so that if there's a contravention, once we tie these loose ends and we issue guidelines with regard to how a PIA should be conducted, we want to have, if you contravene POPIA, we want to be able to impose a fine immediately without affording you that opportunity.
All right. Thank you. Yes, ma'am.
Thank you. I think mine is also directed to Advocate. I'll
Please, your
just
name
introduce
and-
myself.
Yes.
Thank you. I'm Tembisa Mabunda from Office of the Premier. I've heard your response to the previous question. My interest is on the telemarketers. I've seen that you've been issuing enforcement notices, but as a data subject, I have not seen any improvement. So what I want to understand is, are you winning the battle? Are you doing enough to protect us, the general public, from the telemarketers? That's my interest. Thank you.
Thank you. As Advocate Buikanyo notes the question, may I hand over to the chairperson for an intervention?
Thank you very much, and thank you to all the presenters. I actually like this type of engagement where we have a discussion, and I'm not really attacking the presentations that are going to come, but I mean, this kind of thing, I think it's more beneficial because we can have a conversation. My question is, and I'm directing this to Charlene, we have to have a whole of society approach if we are to win the battle of protecting personal information, because, the technological companies are ahead of all of us. From where you sit, you think that everyone is on board? And I'm linking that to the question of, to what Amanda was saying about opportunities, that data protection has opened more opportunities. Do we think universities are on board, for instance, in terms of designing a course, or even not even a course, a degree, in data protection? Do we think that the judiciary is on board as well? Especially because I'm not sure where the training of judges happen, and whether in whatever training or whatever they do, whether they look at data protection, because if they don't, if cases go to court, we're going to have a lot of hit and miss, regarding the interpretation of POPIA.
Thank you, Chair. Is the University of Limpopo in the room? Anyone from UL? No. Okay, no, that's fine.
let's start with Advocate Bukhanyu, then I'll come to Dr.
Yeah, Temi, so something that really keeps us awake at night is direct marketing. You know, even as employees of the regulator, we get these calls. And just to say to you that there's been a difference of interpretation between us and responsible parties. And maybe before I get to that, I need to upfront say the following. We are aware that there are organizations out there that sell personal information of data subjects. There are call centers that are established, and there are millions that are made through the sale of personal information. This is something that we are aware of. And now, in us trying to deal with this issue of unsolicited direct marketing in terms of Section 69 of our Act, we've had to engage with our sister regulator, the National Consumer Commission. There's an overlap that we have with the NCC in terms of this particular issue. But what we've done is that we've ring-fenced cases, we've ring-fenced matters, complaints that we've received. And what we've done is that we have referred a test case to the Enforcement Committee. Our interpretation after our research was that telephones fall within the definition of electronic communication. Responsible parties out there seem to have a different view. And when we, in our engagement with this particular matter, and it's not a secret, it's our assurance, it's a matter of our assurance that we've referred to as a test case to the Enforcement Committee. And I'm not going to go into details around those because the members sit on the Enforcement Committee and they would be the ones that are going to make the final determination with regard to this particular matter. But suffice to say that what we are going to do is that that particular matter is going to determine the course that we're going to follow as a regulator. We anticipate that there's going to be pushback. We anticipate that we're going to be taken to court, and we are ready for the fight insofar as our interpretation as the regulator is concerned. We've interacted with NCC. We think that the process is slow from our sister regulator, NCC, in the register that they're supposed to have promulgated. And you know, that's where also the holdup is with regard to the other leg of insofar as this particular matter is concerned. I hope that answers you.
All right, thank you. Dr. Christoph?
Chairperson, thank you for the question. I definitely agree with you that we need to take a society-wide approach. And on the question of whether data subjects like universities and the judiciary are on board, so I want to say yes and no. So I've seen at some universities, it was after my time, that there are increasingly either master's modules or modules as part of the elective models under the LLB where they do deal with information processing. I mean, in my time, it was internet law, which was ESTA and those pieces of legislation. But I do think there's definitely education to be done there and conversations to be had with universities about the importance of these types of courses and education. Because, I mean, what we've heard today is that new careers were created out of POPIA, and that means that people are going to have to be trained into these careers. And university courses are ideal for that. I think the other element that I want to touch on is that we only really buy into POPIA and realize the potential risks of data processing when we experience something that we don't like. Then we go, oh, but isn't there a protection against this? Shouldn't I follow up with someone? And I think that is a hurdle that we'll see across the country. I mean, when we heard the presentation about who's aware of POPIA and what it does, is I think I'm only aware of POPIA because I'm a lawyer, and even as a lawyer, I do struggle to navigate it, and I mean, I can read legislation. So I think the education element is going to be very important in getting general buy-in. I think perhaps we should also start thinking around how to use WhatsApp, what it's good for, and that's reaching the masses as part of education. And then the last element is the judiciary. The cases that we've seen, I mean, it has been hit and miss. I think they could be on board, but I would say that from what I've seen from legal developments, what would be based is if we have an actual strong Supreme Court of Appeal judgment or a Constitutional Court judgment. If it's a High Court judgment, it needs to be significant enough and sort of advertised enough and be able to be a public interest case. That goes beyond just the individual. I mean, at the Legal Resources Center, we are looking into building those types of cases, but because data subjects often don't understand their rights, I mean, I'm not gonna go to someone's bedside and say, did you know that your data, that this data processing is not okay? So building a case is also then complicated. I think this is a very roundabout way of answering the question, but yeah, I think it's a very yes and no thing, and we're still early days into, I mean, even though it's been quite a number of years since POPIA has come into force and that we've been doing this work, I think we're now only really starting to see the interactions with individual data subjects as opposed to businesses and compliance and that type of thing.
Yeah.
Please.
Thanks, Charlene. I think I just want to add to this conversation around the education and education, tertiary institutions actually having courses that specifically speak to data privacy and POPIA. So with the advent of AI, which I think we can arguably say it came after POPIA, what we have seen happening in universities is there's now specific degrees that have been, and diplomas that have been tailored to equip data scientists, data architects to actually be able to then have a career in AI in an organization for whether it's under data and analytics or what have you. But we haven't seen the same response to POPIA, to the extent that when it comes to AI, it's not only at university level, it's gone into high school, where they've got courses specifically catering for where back in my day, and I was in high school a few years ago, back in my day, you know, you had history, you had mathematics, you had bio, you had physics, you had economics, and you could choose, you're doing commerce studies or different. Now they've actually got specific courses that speak to data science. So, and then it goes further. If you go to a preparatory level, they are now even in preschools. So I've got a young baby, so I've been doing a lot of research around schools, Montessori, etc. They've actually got play, it's not really studying, it's not courses, you won't call it courses, but in their playing, in their schedule for the day, where they're being equipped to understand AI and gaming. But we're not seeing the same response to POPIA. And I think the reason for that is because POPIA has been widely accepted by institutions at large as a compliance requirement.
Yes.
So because it's a compliance requirement, you know, why do we need to do anything outside of what we've done for any of the other laws? Yeah. Why do we need to do anything outside of what we did when POPIA came into effect years ago? So as a result of that type of posture that's being taken around what privacy is, we are getting the type of response from both the public sector, from Parliament even, and from private schools that could actually empower and enable these types of careers that we now find ourselves in.
I just want to piggyback on this point you've made around AI. Of course, there are issues around the development of different AI systems, the building of large language models, the LLMs, and how those models get trained using data sets that may have personal information within them. So I want to piggyback on that point and say, why are we struggling with the concept of privacy by design? And this question is to you. Why do organizations, when they set up their systems or when they design their systems or create products or services,
why is it such a struggle for them to build in privacy right at the start? And I'm using the example of AI, but you can explore it however way you want.
Largely.
And please define the term for us, for those of us that are not aware of what that means.
So when we talk about privacy by design, it basically, in simple English, means you must make sure that whatever systems, products, solutions that you are building in your organizations have privacy at heart initially at the start of those systems. So whatever would be the requirements that we would have insofar as protecting personal information and controls to protect personal information, you put those controls at the foundation of those systems, products, solutions, etc. Now, to the point around why it is a challenge, and it is a challenge. It is a challenge, right? There are privacy impact assessments that are done to determine the impact of a particular system to the privacy risk in organizations. But a lot of times, it's almost a reactive approach. Yeah. A number of the institutions that are successful in this country and that are, whether it's especially public sector, private sector as well. I mean, you've got organizations that have been around for hundreds of years. They've got legacy systems. They've got systems that they are currently advancing, right, to align with the digital age and technological advancements, but they are old systems. They're pre-existing systems. There's an entrenched and well-understood way of utilizing these systems. This is how we do things. This is how this platform works. And then coming almost after the fact to a degree to say you must be private by design, the answer is we've already finished designing. We've already designed it. So, and we are not designing because we are just being innovative and we are, you know, trying to find different ways that we can do things. No, we're in the business of doing business. We are designing systems, we are changing systems, advancing systems because we want them to make us money. So when you now come as a privacy officer, a data protection officer in your organization, and you say, no, in order for the privacy culture of the organization to be transformed, we need to be private by design. How does this make me money today? How does this enable me to continue with my go-live date that has already been promised to our leadership to be a particular date? Oh no, we are saying you need to go back to the foundational way that you actually set up the system, and you need to put controls in place that limit how you process data. If it's an AI or an LLM, we need to make sure that you actually haven't fed this particular model with more data than we should have actually even been storing as an institution. You need to make sure it doesn't have bias. That is a project on its own. And to a project manager or a product owner, you are delaying what I'm trying to achieve. And it goes back to what I was saying earlier, that there isn't a resistance because people generally don't want to comply with POPIA or the provisions within the legislation. It's a matter of how can we position the requirements in POPIA so that they're not seen as a compliance exercise for the sake of doing it and ticking a box and saying, we've got now proof of compliance for the regulator, but seen as a tool to help us have systems, products, solutions that our customers and clients can actually trust. If you don't trust an organization, you're not going to want to do business with them, right? And you might not know what the provision of POPIA says, but you can feel, which is what you were saying earlier, when no man, something's off here. Yeah. Surely they shouldn't, I didn't expect them to share my information with you. Surely you didn't protect my information and that's why it's out in the public. So people might not know POPIA, but you as an institution understand POPIA, you put the provisions in place, you put the controls in place, as a mechanism to build trust with your customers, with your clients, so that their experience of the services and the products that you provide is then private by design.
Thank you. The program director is looking at me, and I think we need to draw the session to a close. But let me give my panelists a chance to offer some concluding remarks. Looking forward now, the next 10 years of the information regulator, the next 10 years of POPIA, where should we be focusing on as stakeholders in this area? Each one of you can respond to that question. We'll start with you, Chris.
I think my answer is going to be obvious, which is just I think we're gonna have to start grappling with social media companies and their impact in processing personal information. Because I mean, if we work from a perspective of systems were built long before POPIA and AI, etc., then we need to face the consideration of that companies might just do what they need to do for minimal compliance and sort of see what they can get away with in terms of processing and the potential impact that can have on, I mean, all these beautiful rights that we have in our Constitution. So.
Yeah. Amanda?
So I was taken aback by a statement, not taken aback in a negative way, in a positive way, but a statement that the chair said when she was doing her opening address. And she said, the need for reform signifies that technology is not static. So I paraphrase, right? So this requires that our approach to privacy must also be agile and practical. I think I've said before in one of the engagements that we had last year in Feb, that we can do more together. Right? If we've established, and by we, I mean institutions, the regulator, private, public sector, centers like the Legal Resource Center, if we understand that we've got the same objective, as someone who is responsible for data privacy and the protection of personal information, you yourself require and expect that your own personal information be protected and treated in a responsible manner. So that means we've got commonalities. Yeah. Right? But at the same time, we've got different resourcing and capacity and capabilities. Institutions are, I'm being dramatic when I say crying out, for partnering with the regulator around how can we translate these principles into our day-to-day operations? How can you help us to make sure that we're doing the right thing the right way? Because ultimately, if I win on privacy as a responsible party, I win also in the pocket because I've built trust and then I get more clients, right? And then if I'm doing the right thing, it makes the burden on the regulator less, because then you don't need to be spending all your time and resources on doing assessments, because you have the assurance that the organizations that are large enough processing large volumes of data, especially in the public sector and some big institutions in the private sector, are doing the right thing the right way. And you're close enough to know, not coming with a stick, not coming with a carrot, but coming with an approach of saying, let's sit together, let's partner, let's learn from each other so that we better understand your institution and we're better able to assist you so that you assist us to not need to have 10,000 employees in order to enforce POPIA.
Absolutely. Advocate Boikanyo?
From a regulatory perspective, I think that we've got to encourage mandatory privacy by design practices. We've got to encourage, and Amanda somewhat touched on it, we've got to encourage responsible parties to assess privacy risks at the planning and design phase of all systems that involve the processing of personal information. But also further to this, we've got to have regular legislative and policy reviews. I think there's a real tension point between AI, just as an example, and POPIA, and I can mention a whole lot of examples. Automated decision making. For Amanda, it would be easy for her to, when there's an application in the bank, for credit, for purposes of credit scoring, to use AI in the recruitment process, to use AI. But these are the sort of things that we've got to look at. We've got to look at AI versus POPIA. The other issue that I think we should look at would be ensuring that there's consistent and visible enforcement. And by this I mean that we issue enforcement notices as a regulator and administrative fines to enhance enforcement with POPIA. That we also follow a risk-based approach. We look at those areas that are higher risk in terms of the processing of personal information. Your healthcare sectors, we look at your finance sectors, your government departments. In some of the government departments, they take POPIA, and when we assessed one responsible party, POPIA was put in records management. Somebody in records management was responsible for POPIA. But more importantly, I think we need to strengthen the information regulator. And when I say strengthen the information regulator, I'm talking about strengthening it from an increased funding perspective, strengthening it from specialized skills and investigative capacity. This would ensure that as a regulator, we go a long way in ensuring that we protect the rights of the ordinary man in the street.
Absolutely. Thank you so much, Advocate Boikanyo. Like I said, colleagues, this was a starter. A lot of big themes were put before you as part of this panel discussion. And a lot of these themes are going to be unpacked when we go into the breakaway sessions. So if you still had questions to ask or comments to make on any of the issues that were raised during this panel discussion, you will have another opportunity when we break up into those breakaway sessions for further engagement. But please help me appreciate this panel. I think it was an excellent panel, great insights. Thank you very much, members of the panel.
Thank you.
For that.
Perfect. Thank you, members of the panel, and Mr. Demba as well. We've heard several important points about how real practical day-to-day organizational life in the public and the private sector are interacting with POPIA. But you deserve a break now. So we are going to have a comfort break for about 15 minutes. It is, let me just check the time right now. It is 11:30. We'll return at 11:45. And then the next sessions that we'll be going to is the compliance breakaway sessions. But I'll talk more about that when we return. Thanks. Oh, the comfort break will be to the left in case you need to go there. And the restrooms on the right-hand side. Okay, perfect. It would be great if everyone could start returning to the room as we'll be beginning the compliance in practice session soon. Little comfort break we had right now. Please don't worry, there will be another opportunity before you go out to the breakout to actually take a beverage or something to eat. But session 2 really focuses on compliance in practice. A lot of people and organizations generally complain that POPIA is law and it's theory and I don't see anything concrete or tangible out of this. Well, this session is for you in particular. We're going to have 3 breakout sessions, which I'll get into in a bit. What's important to note, though, is that it will be split across 3 venues. The first venue is this venue over here, the main session. Then there is the church, which is across the way, and then also the Day Lily room. Now, each venue does have its own restroom, so please don't worry about that, and you're welcome to take drinks, your beverages along with you. However, we slightly have to limit time for the session. We have to cut it by about an hour, unfortunately. So what we're going to be doing is I'm going to request that each of the presenters for the breakaway session limit their actual talk to about 20 minutes. That discussion is left aside, and then when we come back to this venue, when everyone comes back to this venue, we'll deal with questions in a sort of discussion format. So the first person that I'd like to introduce will be talking about privacy policies, navigating policies and consent in practice. That would be led by Advocate Dironto Mohale. Dironto, would you stand for us so that everyone would just know who you are? Dironto likes long walks on the beach and endless mimosas. So that will be the first session, and Dironto will be in the church. Then, secondly, we'll do a compliance framework and risk session. And it will look at compliance frameworks and risk assessments under the POPIA Act, and it will be led by Ms. Mohanganai Mbedzi from the Information Regulator. Would you please stand? Thank you. And so you'll be in the Day Lily room, and then lastly, the session that will stay in this venue would be on security safeguards, and that will be led by Mr. Langitemba Mazibu. Would you please stand? Okay, great. Thanks. Thanks for preempting that. So please go ahead to the sessions, use that exit for the breakaway, and then we'll be back in this venue at 12:20. Thank you. Okay, so I see the exit behind you on the right-hand side will be opened. The last breakaway session will stay in this venue. Please don't worry about that. But I see that the door has been opened on that side, so you can exit there to both the church venue and the Day Lily room. Please go ahead. If you do have any FOMO about any sessions, please don't worry. We'll come back into this venue and discuss each of the topics. So please try not to saturate a particular venue. Split it out and enjoy.
Thank you, everyone. I'd like everyone who's here for the security safeguard sessions, if we can maybe congregate in one area, maybe in the center of the room. I see we're very scattered. Or in the center, yes, so that chair doesn't move. Maybe let's come to the center of the room. Oh, thanks. Forcing me to write, huh? So, thank you very much for joining this session. So, just to kick it off, I'd like to welcome all of you. I think there's too many of us to introduce each other. It'll just take up the whole day. But can I get a sense of the industries we all come from? I know Mr. Mtsweni is in cybersecurity. I've got Amanda in privacy. Is everyone working in cybersecurity? Privacy? Oh, I see. Okay. Can I just pick on people in the room? And which industry are you in, sir? Cyber law? Academia? Great stuff. Yeah, so I think we've got the right people in the room. So I'd just like to kick it off by just making a statement on some observations that the regulator has seen while conducting compliance assessments on responsible parties. So, security safeguards are basically regarded as just technical measures. So that is what we've seen. A lot of times, the responsible parties we see jump straight into implementing technical measures. I think this is because you have a lot of marketing around, these nice words in terms of cybersecurity tools that will do everything for you. You don't have to get anyone to look after them. They're AI and they'll just catch everything. However, people want to make money and that is what they'll say. So a lot of bigger companies will have everything in place in terms of security, including the organizational measures that inform those technical safeguards. So I don't want to be here preaching to the choir, but I do want to get a sense from around the room. Because from our observation and from the way the Act is structured, the progression comes in the Act. It talks to 19.1 that dives straight into what you should prevent. But 19.2 then talks to how you identify what you should prevent. So that talks to the risk identification that you should be conducting. So you've got all these informational assets around you in the environment. You've got the data that you are taking care of. You've got the systems. But how do you now start to protect all these assets? So the first part, the Act recommends that you do a risk identification process. Now, once you identify those risks, you will then determine what mitigation measures you need to put in place, right? Once you have those mitigation measures, those become now your technical measures. But how do you enforce them? Now, you can have measures, and if people are the same everywhere, they will always take shortcuts, and that's why we have policies. Policies are directive in nature. They force people to actually act in a certain way, in a way that flows for the rest of the company so that everyone knows what everyone is doing. However, we've also seen that a lot of companies understand that we need to have those organizational measures. And it's kind of a box-ticking exercise where we'll just go out, get someone to develop a policy for us. But that policy often doesn't talk to the environment, doesn't talk to what you need to protect. And as such, you find yourself wanting, when something happens, we come through and we can't find how you are protecting certain assets in your policy. So from there, you have the standards that are recommended, the best practices that POPIA recommends you put in place. These best practices give you a guidance on how you implement those technical measures, how you document them, and then you have that leeway to choose the measures that apply to your environment while leaving out everything else that doesn't talk to what you are doing as an institution. So I'd like to get from the room what challenges you think cause organizations to not go the full route of starting with the risk assessments, developing the policies that inform these measures and comply with the need to have these measures based on best practices. So I don't know who will kick us off in the room. Thank you very much. And if you just give us your name and where you're from, and then you start. Thank you.
All right. Good morning. Actually, it's 1 minute past afternoon, if I'm not mistaken. So, yeah, my name is Tsaike Phineas Makobotwan. I'm from Cyblex, which is a compliance company, an AI training company. I'm also a master student at UJ. So, in my question is actually related to what I was actually researching about the whole of last year. So my research was about Section 19 in particular. So what makes companies to not be able to do what you're saying? So if you look at Section 19, it's talking about reasonableness. Reasonableness on itself is it's a long-standing principle. So when we think about reasonableness, we would think about the Kruger versus Coetzee case, whereby we would apply a reasonable test to any particular situation. So now, organizations on different tiers, the NIST categorizes organizations into tiers to see. The first thing that we have to do is to identify, right? So when we identify, when we start to try and implement, which is now when we are going to subsection 2 and 3 and trying to implement the security safeguards, what organizations do not know what is reasonable for their circumstances. And also, if you look at it in terms of the judiciary also, how does the courts also go about trying to interpret in a particular situation? Is there a particular test in terms of data protection of how do we now say for this size, for this type of organization, this might be reasonable. In labor law, we do have those things that they say if you have this certain number of employees, it would be reasonable to comply with this kind of standards in terms of the Basic Conditions of Employment Act, blah, blah, blah. But in terms of the POPIA Act, how do we now scale that and say, this is the size, this is reasonable? And then if it's a best practice, we do have things like the King Codes. But then in terms of cybersecurity, how does a small enterprise or medium enterprise say, what I have implemented is reasonable? And then if ever they are held liable, how does the court now say, in these particular circumstances, when we apply the reasonable test in data protection, right, this was reasonable and therefore maybe the accountability part will be done away, to say we applied all the reasonable measures that we could, but then there was still maybe a penetration or a cyber attack, right? So what makes organization fails is the understanding of their particular industry. Big financial sectors, they do have those. They have policies, they have regulators in their body. In the legal industry, we have the Legal Practice Authority, the Legal Practice Council, right? In the financial sector, we have those FICAs, financial sectors authorities, right? And here we have the information regulator now. How does the information regulator come forward and say, this is reasonable for this particular organization, so that if ever when they do identify, they say, okay, this would be reasonable for us to implement. Even when there's an assessment, the assessment is based on the reasonableness of that particular type of organization or industry. Thank you.
Thank you very much. I don't know if I should be the one answering your question, because now we run the risk of playing both player and referee. I'm saying that to say this. All organizations are unique in their operations. Obviously, there are organizations in the same sector, but even there, they've got their own IP. You are the one who knows what you have implemented. Now, this risk identification process talks to you identifying your information assets. If you know all your assets, you know all the possible points of entry. Maybe you might not know all of them, but if you can identify all the ones that can reasonably be identified. I mean, someone might come in tomorrow using a quantum computing tool that is beyond what we've ever seen in terms of cracking passwords. Now you have a password that is 20 characters, but some quantum computer was able to crack that password in maybe a minute. But you have the appropriate measure, right? So there are those circumstances that we may come across, but obviously it's not what we're dealing with now. I don't want to be the one who prescribes what measures. Let me give it to Chair, and maybe someone in the room will be able to guide us in terms of responding to you.
No, I'm not responding because you have to determine for your own industry what is reasonable. However, the only point that I want to make is that you need to read reasonable with appropriate, because the Act talks about appropriate and reasonable. So that's the only point. But to tell you what is appropriate and reasonable, now when we come and assess you, then you say, yeah, Tlakula said this is, or Mazibu said this is what is reasonable. No, we're not going there.
Thank you, Chair. Maybe we can have another cybersecurity mind in the room. Any thoughts on the question that was posed? Any takers before I nominate for myself? Advocate Boikanyo.
Yeah, maybe I shouldn't be responding because of the assessments, Mr. Mazibu, that we've conducted. But one thing that I've picked up is that cyber security is very expensive. And that is why sometimes you have a challenge with regard to complying with this requirement to identify the risk. Also, the issue of the lack of skilled staff. In a number of our assessments, we've identified that the responsible parties don't have skilled staff, and then there's also the over-reliance on operators. You will find responsible parties outsourcing particular services, and they then think that the operator will comply with this requirement of the identification of risk. I thought I should just raise those three. And maybe the last one would be weak ICT governance and accountability as the fourth one.
Thank you very much, Advocate Boikanyo, for those inputs. I think from my side as well, these are challenges that I agree with Advocate Boikanyo that exist. And maybe from us now identifying these challenges, and I do get what you're saying about the small enterprises, and because the cost really talks to, those smaller organizations not being able to, act like the bigger ones, where some company will have a budget of 10% of their turnover as cybersecurity. So now, if they've got a 2 billion or 20 billion rand turnover, that means they are spending like 2 billion rand just on cybersecurity. Now, you can't compare that kind of organization with Stockfell, because I want to make this example because Stockfell's process personal information. And once you start processing personal information, you're a responsible party and you need to be compliant with the Act. We haven't assessed Stockfells yet, but I'm just putting it out there. So now, there are those organizations that are maybe a bit small without the requisite funds, but if we're talking to outsourcing as well, this goes to a lot of some of the bigger ones now who will outsource skills in cybersecurity or information security, but this same company that they're outsourcing also works for that guy, works for that guy, works for that guy, and if you look at the policies, they are all the same. They've done one policy, and then they just shopped it around and dropped it on everyone's desk, and everyone looks at this and says, oh, wow, this is so comprehensive, but does it talk to the environment that you are operating in? So maybe, are there any business owners in the room? Small businesses? Okay, thank you for assisting here, because hey, the people in the room are... I just want us now to go to maybe what can be done in terms of assisting, the smaller businesses get to where the bigger ones are. I know it's a difficult challenge, but we're here to answer questions. As we build this organizations, we need to understand what the challenges are, and maybe in us assessing, because our job is to promote protection of personal information and ensure that the data subjects' needs are taken into account. So we can't only do that by policing the organizations. We have to also, allow ourselves to develop guidance, even though it won't be prescriptive to say these are the measures you should put in place, but for us to develop guidance knowing the challenges that are faced. So are there any maybe suggestions in the room on how we can maybe start off that path? Thank you.
Thank you. For me, as a government department, and sharing from the challenges that have already been identified, what we have seen, and I think it works for us thus far, is making sure that we workshop our officials, make sure that every month there are awareness campaigns to make sure that we reach all the officials. Because for as long as our officials are not aware of the do's and don'ts in the cyberspace, we are vulnerable. And as indicated, that cybersecurity is very expensive, and as government departments, we don't have that much budget and the skills to address the challenges. So we are making sure that we conduct awareness campaigns to prevent those challenges that can be prevented based on the user compliance to our policies. Thank you.
And I think that's a very good point in terms of talking about awareness campaigns, because at the end of the day, whatever we are dealing with in terms of cybersecurity comes back to the human being. And there's a saying that a chain is only as strong as its weakest link. So you might have all these measures in place and you're putting them in place, but if you don't have the people, are you really making an impact? And if those people are not trained, what is the impact of that? Thank you.
My comment would just be around, like you mentioned earlier, we're all from different industries, right? And each of the businesses have different sizes, different risk thresholds. You might find a small private business that is collecting very minimal personal data. So my recommendation would be that let there be some sort of risk matrix, depending on the volumes of data that you are processing. These would kind of be the guidelines, like make sure you have a privacy notice, make sure you have a DPO, you've registered with the information regulator. But in the event you fall within medium, you might need to have more stricter controls. And if you then fall within very high risk and you're dealing with large volumes of data, then you would need to then meet a higher set of criteria. And like Advocate Bucanio mentioned, that it is expensive, but unfortunately a breach can be more costly as well. So the higher the volumes of data that you're dealing with, the higher the risk, the more money you would obviously have to input into it. So a sort of, yeah, risk matrix, yeah.
Thank you for that input. I'd like to, Chair?
Just out of interest, how many people are from government departments in here? Quite a number. And I mean, we heard you speak. I just want to find out from others whether what you are hearing here resonates, and are these practices that apply in your environment? Are you being trained on these issues? Just to get a sense from one of you, because, you know, the private sector, we know we deal with it a lot, but we see, at least from where we're sitting, gaps, big gaps in the public sector. Maybe because I'm looking at you. Let me volunteer you.
Okay, no, thanks. Yeah, where we come from, yeah, the issue of security is a very serious issue. And then currently we've got strategic plans in the department which we are following in order to guide us on how to protect our environment. Coxter. Cooperative governance, human settlement, and traditional affairs.
Maybe.
Thank you.
Maybe I can just, I'm from the same department with her. Maybe I can just add with regard to awareness, that awareness is done, but enforcing or allowing those colleagues to participate in this awareness is also a challenge. We can put awareness on, it's either electronic workshop, but not all participating officials are participating in awareness. So my suggestion is to enforce such in a way that there must be somehow where if a person is unable to participate in some kind of awareness, we're able to block some access into some system, something like that. I know sometimes we might be contravening in some of the policies that all access must be given to officials who's doing those work. But I think most important, enforcement of that participating in awareness, because the departments are really doing awareness. We keep on having quarterly awareness. We are putting posters, but is it really being enforced, or people are participating? Are we doing survey to check if officials are able to, they know what's happening in terms of that? Thanks.
If I may also add and respond to the question by advocate, as the provincial, I'm from Office of the Premier, responsible for provincial ICT. So we arrange these awareness campaigns and cybersecurity assessments with the assistance from CETA. So we also assist departments in providing the posters so that they can share with their users. So on a quarterly basis, we monitor them on the work they are doing in terms of cybersecurity implementation and ensuring that these awareness campaigns are conducted. So we monitor that on a monthly basis. As Thando has responded, it's difficult because sometimes you find that there is lack of interest from the officials. So those are the soft issues that we are dealing with. But as a provincial office, we have those measures in place to make sure that departments are supported in terms of managing cybersecurity. Thank you.
Thank you very much for that. But it does bring me to a question that's now lingering in my mind. I'll be right with you, Peter. As to the type of skills that are available, is there any monitoring done, maybe from the Office of the Premier side, in terms of the type of skills? Because there are IT skills, general IT skills, and there are information security skills. And a lot of the time we conflate these deliberately because we don't have the skills. So we just say, no, we've got an IT person. Né? But we know it's not information security, and there is a gap because someone can come and implement something, they know about something, and they'll say, yes, this is what we need to put in place. But in terms of documenting that, ensuring that this is the right tool we're putting in place, this is what we actually need, is there an effort to ensure that the departments are actually hiring the right skills for the right jobs? I mean, to align people with the actual jobs that they are doing. And I'd like to let you think about that and maybe just take Mr. Van der Walt.
Thank you. Also remember, despite putting all of these controls in place, if you're not going to monitor, like you've mentioned, if you're not going to test, etc., they're just a box doing something and nobody looks at them. What we've also want to make sure of is, if there's a breach tomorrow or now, what do you do? Who's involved? What's that reaction, incident response plan? It's all fine. We've got all these nice, pretty blinking tools, and it's got its little lights and nice reports. But who monitors it? Once that attacker gets in, who's on that list to be communicated? What actions do you take? And the other thing is, make people go through desktop exercises or playbooks to test their readiness. There could be a breach tomorrow morning at 2 o'clock in the morning. What are your action plans? Who gets called? What gets switched off? What gets pulled? So those are important things, despite all the controls that you've got, that you have to take into account. Yes, I agree, private sector, there's skills, there's money, well, not always, but there's definitely resourcing available. I'm very concerned about sharing or outsourcing sensitive processing of personal information to small enterprises who do not have the capacity or the capabilities. However, we know the situation in our country with regards to jobs, making opportunities available. But we also, and I think to our earlier discussion, is understand what is your risk profile? What are you being asked to process? Is it mundane information for a small campaign for marketing, or is it sensitive health information? And does your risk profile and controls, are they commensurate with that particular situation that you have in place?
Thank you very much, Peter. I think you bring us to a very important part of this discussion in terms of what happens when a breach does occur. Because you may be a big multinational with a 2 billion rand budget for cybersecurity, but breaches or security compromises do occur. So once that occurs, what do you do? So I find that is another area of guidance that we need to include here in terms of the incident response. And I don't even want to go down the road of maybe asking, let's take the public sector in the room. Are there incident response plans in place? Have they been tested? And, have any, exercises been done to say, okay, should a breach occur, this is what we'll do? Because we have found that a lot of times, once breaches occur, it is very reactive, where at that moment you start bringing in cybersecurity professionals and companies to come and deal with the actual compromise once it has happened. 2 days or a week after this has happened, you have your IT guys investigating. They don't know what's happening, but they are under pressure to come up with a solution or to explain to the principals what has happened. So in terms of, let's take the public sector in the room, what kind of incident response
Yeah, I'm in trouble. Thank you very much. I think you are asking a very important question that needs to be responded to. Let me first respond to the question around skill and the recruitment of the relevant skills. Departments, as we monitor them, there are a lot of departments that do not have those information security officers, those cybersecurity officials, specialists. So we are struggling in that, and we have tried as a department as well, and they don't come cheap. That's one of the things. And remember, our recruitment policies, we have got those levels, and when you compare with the specialists that you can get, they come at a very senior level compared to the government. So we can't we are struggling to fill those posts. Then coming to the cybersecurity strategy and your response procedures and plans. Fortunately, as a province, we have done the assessments before, and then we saw that there was a need to develop that strategy, and it has been approved, and we had that cybersecurity response procedure. The challenge that we are faced with now is departments, they don't test. That's why I'm saying I'm happy that you are raising it so that they see that the test is not for us to see whatever, it's not for, it's for to help them as well, so that the gaps that we pick up from that assessment will help them to make sure that they close those. So I would encourage departments that they should look into that test, and it will also give feedback to us as to now review that procedure manual to say these are the areas that we overlooked and then we need to address as a collective. Thank you.
Thank you very much, and I think we have run out of time. It was still an interesting conversation because we've been dealing with only the online aspect. I wanted us to talk to the security safeguards for also offline resources, because that's what information security management talks to. It's across the board, both online and offline. We've got, papers on desks. I mean, that's an information security issue all by itself. There are security safeguards to put in place there. They may not be as technical, but these are measures that talk to the awareness campaigns that we need to run. And on that note, thank you very much, colleagues, for the participation in this session. And let's allow the other colleagues back in so we can give feedback. Thank you very much.
As everyone's returning to the venue, I'd like to ask the leaders or the facilitators of those sessions to please join me on the stage. Okay, so we'll be starting in 2 minutes. We are just waiting on one of the facilitators to enter the venue. Okay, so I see everyone has returned now. I just want to caution our late facilitator that you may be a candidate for an enforcement notice sometime very soon. But could I please ask each of the facilitators to please come to the stage for our synthesis session. Okay, perfect. So a few of us were walking around to the different sessions, and we heard that it was pretty engaging. And one point that we wanted to draw from that is that there is a very deep need for further discussions on these topics that today can't accommodate, but what it can accommodate is starting those conversations. And so my first, what we'll do now is get an overview or synthesis of the sessions that just took place for the benefit of everyone, and then we'll go into a sort of discussion format where the floor will be open for questions on any of the topics that are discussed or will be discussed, and we'll take it from there. So I'd like to start, let's start on the left with Advocate Mohale.
It's all right. Left is that side.
Yeah. My left.
Good afternoon, everybody. We have the pleasure of being the last panel just before lunch, so we won't waste a lot of time from my side. I think we had the privilege of discussing navigation between consent and processing limitations, but under the bigger umbrella of privacy policies. So when we started, it was just made clear that we are looking at two conditions. We've got the condition of accountability, where your privacy policies would fall under, and then we've got the processing limitation, is where your consent would fall under. We did not have enough time to even go past the introduction, but we did discuss a few interesting matters. Generally, when we should not be using consent, and whilst access to information also falls under POPIA, it also is in the context of POPIA. So I'm just going to ask my audience that I was with just to give their view on what they learned, as opposed to me speaking. Today I didn't speak so much, so I will continue that trend. Can I start with you, sir, where we were discussing basically the request by self-regulatory bodies for information of their members from a responsible party. I think you can give the details.
Well, actually,
can I get the mic over there?
Okay, there's a mic over there. But actually, before we do that, a question that comes up a lot in the general broader public is that, well, POPIA doesn't use the word privacy policy. Why do I even need one? So would you be able to address that?
Okay. So when we implement any legislation, right, as compliance, as institutions, etc., we need to make sure that people need to know what the organization's stance is on that subject matter, here being data protection. People need to know exactly what it is they need to comply with. As within a law, if people don't know what to comply with, we can't hold them accountable. So it's very important that we have, where POPIA does come in is talking about compliance frameworks, and policies are part of the framework from a governance perspective, from an accountability perspective. So we need to make sure, though, we understand from a governance perspective, from a data protection perspective, when we talk about policy, what exactly it is that we are talking about. I find that in a lot of organizations, especially in Africa, we confuse in terms of GDPR and other foreign law policy, privacy policy versus privacy statement versus privacy notice. So just to make sure, without going into governance 101, a policy is an internal facing document which speaks to principles of a subject matter, here being POPIA. Then obviously you would go into the operational documents, which would be your SOPs and then your manuals, etc. Your statement would be the organization's outgoing statement to the public saying, this is how we approach data privacy. We also use that statement to comply with parts, not all parts, of Section 18, where we give a general disclosure of why we collect your information, where we store your information, who we share your information with, and some basically why we collect, and how you can also contact us for any complaints, etc., as organizations. Privacy notice is used interchangeably with the privacy statement, but in my space, I use privacy notice as exactly when we are collecting your information. So we've got the statement, which is generally on your website, but when you are now filling in that application for a bank account, for a job, etc., we need to notify you in that process what we're going to do with your information. I know I've gone overboard with that one, but POPIA does make provision for policy.
Thank you for that. I think it provides clarity on a topic that's often contested, but please go ahead.
Thank you. My name is Dr. Leshohotla, and then I work for Limpopo for Agriculture and Rural Development. And in the case that we're discussing about privacy, we also gave some examples of what we got as a department. There was a requester who requested for information relating to the work that was performed by our veterinarians. These are the doctors that are dealing with the animals in the department. And it was affecting two of those doctors. And for them to practice, they need to be belonging to that to the association. And at one stage, the association had that they are performing work without getting the approval, the Arabs. Now, the association came and made a buyer request to say that they wanted to know whether these state veterinarians are performing the work and what their names and other issues that we know they raised in the request. And obviously, we had to write to those state veterinarians to say that we received a request that is requesting information about you. And obviously, they did not consent. They did not want us to finish their names to the association. And we had not to give that information to the association. So that's one practical example that we got from our department. Thank you.
Thank you, Doctor. So that case actually illustrates why consent is not always the best lawful ground to use. At any point, we need to make sure that when we use consent as data controllers, that the person is able to object, and when they do object, and at any time they can object, we need to desist with processing immediately. In this case, we discussed that consent may not have been the best lawful ground to use. Without going into the operations of PIA itself, it's the information officer's duty to balance between the requester's right to access of information about their members and the members' right to privacy, and come up with a decision that would be best suitable. Okay. And then we also had a discussion on social media platforms using consent as part of their terms and conditions, and is this actually lawful in that? Charlene, do you want to expand more on that one? Mike over there.
So,
how much more time?
So I was, we had a discussion after around, given the fact that when you sign up to a service like WhatsApp or Facebook, they either have something along the lines of like, I consent to the use of personal information, but I think it's actually, I agree that if I sign up and use the service, my personal information can be used. And then I was curious about the legitimate, like processing personal information for legitimate interest. So consent isn't required in that situation. And then my question became, but like, is there then ever really a proper way to regulate these social media companies? Because they can say, Facebook, WhatsApp, Meta, whatever, you know, we process personal information because it's part of our legitimate commercial interest, which is connecting people. Part of that can be connecting people through an algorithm with similar views, etc. And of course, then it comes down to, okay, in what way does this then, in what way do those legitimate interests not comply with South African law or the processing of personal information? And yeah, I found that quite interesting.
I think also just from a South African perspective, the information regulator has been going backwards and forwards with WhatsApp in terms of their terms and conditions, how they process in South Africans' personal information. And I think if you're all on the radar, you would have known that WhatsApp not so long ago actually changed their terms and conditions based on this interaction. So regulators are able to change or to basically convince such platforms to make sure that they comply with the country's regulations. I don't know if any of you are on Gmail. Okay. Can I finish what I was going to say, then I'll give you. Okay. I don't know if any of you guys are on Gmail. They recently changed their terms and conditions as well. And in terms of the usage of the personal information and analytics, we were given the option to opt in or opt out. And if you opted out, as I did, you were then bombarded with all of the spam, all of the promotions, all in one inbox that no longer separated the promotions, spam, etc. In there. So while we have rights, we also have to know that these are the consequences, and we need to choose between what we want to do. Can I give to the chairperson, please?
Yeah. No, just a small, clarification. The WhatsApp, it was not as a result of discussions. It was a
court case.
It was a court case because there was an assessment that was conducted, and then we found that their privacy policy, the one that they introduced in 2021, contradicted. It was in violation of POPIA. So we then issued an enforcement notice. After we issued an enforcement notice, they then said, no, we are going to court to challenge it. We said, fine, that's where we'll meet. And then they came back and said, can we talk? So we had a discussion with them, with negotiation. It was a formal negotiation, after which they settled. We settled, and we have the settlement agreement, we're now making it a court order. That is where we are at the moment. Yeah. So I just wanted to clarify.
Thank you for that.
It was not out of the goodness of their.
Well, thank you for clarifying that. And I just wanted to mention one other point about consent before we go ahead. A few colleagues and I in the room were having conversations about this topic on consent specifically and why it's so misunderstood in a South African context and broader global context. And that's because, at least from a legal perspective, traditionally consent was rooted in our rights as legal persons. We can consent or agree to things, and it's part of our rights and responsibilities, and that infused contract law and also the law of delict, when you can consent to harm. Now, POPIA came along as a data protection law and took a different approach to consent, in that the question is no longer can we agree? It's can I say no? Can I say no to the particular item, and whether it's a processing of my personal information or other sort. And so there's this fundamental shift philosophically in the law that needs to be considered. Advocate Mohale mentioned early on that there's the broader conversation beyond privacy notices of this idea of a system, a privacy information management system, if you want to call it. And a big part of that is compliance frameworks. And so I'd like Ms. Mbedzi to speak briefly about what happened in her session and any key points, and then we'll open up for questions.
Thank you very much, and good afternoon once again. Just like Advocate Mohale, we found the session very short. We were supposed to touch on compliance frameworks, risks, and then the PIA. We didn't even get that far. We started off on compliance frameworks, and we were fortunate in our session to have the CEO of the Information Regulator and also one of the members, Member Gwala, in our session, and we had robust discussions. Just as we were starting to unpack the frameworks, the session was ending. But we started off by looking at 3 questions. The first one was, do our compliance frameworks protect people or do they protect organizations? That was the first thing. Then we wanted to see, are our compliance frameworks owned by organizations as a whole, or are they delegated? And are they integrated with business? Because more often than not, we find it becomes a compliance function, it becomes a legal function, and they sit in their little corner and they don't integrate it with business, who actually does the actual processing of personal information. Then we asked, do our frameworks work under stress? When there's a data breach, when there's an investigation, when there's an assessment, will our compliance frameworks work? And what we came out of the discussion, and I'll ask, there's a lady there in the front, in the corner, she will give us a roundup of some of our discussions. Our session had 90% members from the public sector. And what we got is that what we did when POPIA came into effect is everybody ran around and started putting things on paper, just so that we could tick the box to say, we have the compliance framework, we have the privacy statement and the privacy policy. But the question that now sits in front of us is, how is it being operationalized? Because the CEO made a comment to say, as a regulator, when we receive the complaint, 9 times out of 10, it's not to say, do you have a privacy policy in place? It's what has been put in the privacy policy. Is it actually working? How are we operationalizing it? So I'll ask the lady in the front here to just give us a roundup of some of our discussions, and I think the CEO will then also weigh in with Mr. Gwala on some of the discussions. It was very short. We didn't even get into the PIA, but let's get a bit of a roundup of what our discussions were about.
Just before the participant goes ahead, would you basically be able to define a compliance framework? Because as far as I understand, there are various concepts floating around what it may actually be, but it would be good to get the regulator's understanding on that.
And that's one of the things that we spoke about. One of the very first questions, what is it? Because it's not defined in POPIA. Regulation 4 just says, have a compliance framework in place. And I think Advocate Mohale actually touched on it to say it becomes, from a governance perspective, all of those documents that are required for POPIA compliance are then put into one. But the question then becomes, when we have done that, what happens? So there is, and we wanted to get into, we didn't even get to what then should the regulator do. Does it require a definition? Do we need to define it? Because the regulator is going into looking at legislative amendments. Is this one of the things that we need to look at? How will it help the compliance journey? Unfortunately, we didn't even get to those aspects, but it's one of the things that we then need to ask ourselves to say, it's a requirement, just like the PIA. It's a requirement, and Advocate Wiganyo mentioned it here, that it's a requirement, but there's no guidance on what is it, how should it be done. Just like with the compliance framework, it's there, it needs to be done. And if it goes back to that question of, if you have put privacy at records management, and they are not by profession compliance professionals who know from a Compliance Institute of South Africa perspective what is a compliance framework. They may have some sort of difficulty, but we touched a bit on that, and we'll just get some inputs from the session that we had.
Oh, sorry. Hi, I'm Mapito. So I'll just try and put everything together. So based on the questions that she just indicated, some of the colleagues shared what they're experiencing on the ground. And one colleague indicated that they are from a company named Massive, which was then, well, Vodacom purchased 30% stake. But now it raised an issue of, now with the issue of transitioning from a compliance point of view, how would it work or how is it working? And the issue that also came up was normally what you would find with entities that either are subsidiaries is that they would normally leave the compliance to the head office or the group, which then posed a challenge. And I remember there was a colleague who then indicated each institution or each entity should be dealing with the issue of compliance on their own instead of just referring to everything to the group. So that was one issue that was raised. And for me, coming from a public sector, it just indicated, or at least lit a light in terms of what we do as a province. We had a colleague that came from, that comes from the Office of the Premier who indicated how they sort of run the province in terms of educating everybody and making sure that all the departments comply. But the issue that I then raised was, but now you are the group in the head and we just take off without necessarily understanding what we are doing. And then, it's literally just a compliance. Oh, they want this quarter, we sign off, submit to them, it's out of the way. But when actually somebody walks through the door and they want to check whether what we've actually indicated on the checklist is actually what we're doing, the picture would be totally different. So I think the idea, coming back to what we had to engage on from an
losing it. Operationalizing.
Operationalizing, thank you, Mayor. It just indicated that the practice on the ground is not necessarily reflecting back to what she flagged. So we had to prepare the compliance framework. It's all good and well, the paper you have, but when you actually hit the ground, that's not what we put in practice. So the issue that I also flagged, or at least that what we discussed, was that you still find, and I think she touched on it, to say it's a compliance or a legal issue and not an organization issue. And I gave an example in terms of, I'm sitting in a gaming industry, you'd have your legal guys drafting whatever that at the end of the day is endorsed by the board, but we can't literally put it in practice because it doesn't necessarily work for the entity or for the environment that we find ourselves in. I gave an example about the issue of, for example, say Betway, where Betway is regulated by Cape Town Gambling Board, and then you find somebody, because it's a national thing, you can bet sitting here, you come, you complain to us, but we don't necessarily deal with issues of Betway because they're regulated elsewhere. So somebody said somewhere, made a decision without actually thinking that there might be this issue that comes into play where somebody sitting in Limpopo might have an issue with somebody that you are regulating in another province. So it just, for me at least, speaks to issues of operations, I'll just say of operations, whether when we actually make laws or policies, whether we actually go to the extent of would it work when you consider the bigger picture. The last thing that I then raised was, I come from a finance background, and I know the CEO touched on the issue of now when you, from an SCM point of view, it's all good and well, you're done with your tenders, what then do you do with the tender documents? And normally you'd have personal information of directors and whoever's documented there, but those are the issues, at least for me coming from finance, sort of spoke to me to say, actually what you do. He also raised the issue of, there's been a story, and I've seen it myself, where CVs of people were thrown outside. It's got personal information of people, well, not here, I think he said in the Northwest, disclaimer. But then how do we then deal with such things or such documents when we're done? I took it a step further to say, having or at least coming from the finance background, there's the aspect where when you're preparing your financial statements, there's certain information that pertains to certain employees that you need to disclose. How far do you go? And I think I indicated that when this issue of POPIA came up, it was more of,
nobody really knows in terms of what or how do we deal with it, and we just continue as normal. You'd go into the financial statements, you'll find this and that information, whether we're right or wrong. Basically, we're still trying to figure it out. So those are some of the issues that we sort of raised. I'm not sure if I may say anything. Maybe some of my colleagues will pitch in. Thanks.
And I don't mean to stand before people and lunch. Maybe if we could just give the CEO and Mr. Gwala just a 30-second, because they also raised quite important issues around this. The CEO.
Thank you, Facilitator. I think the issues that I raised have been properly reported to plenary. But I think for me is we need to, now that we've had this 10 years and perhaps 5 years of implementation, we need to completely move to executing the mandate. Now, and I won't say it in the examples that I use. The regulator supervises how this mandate is executed. You know, we supervise it, but the people who must execute the mandate are the different departments, entities, and everyone, because they're the ones who receive personal information. They're the ones who process it. And at the moment, we still are lagging behind. We are still in the tick the box where we want to have these things. Now, Chairperson and I receive complaints directly from the public. And majority, if not 90% of these complaints are not about privacy policy, are about how their personal information was not used correctly in terms of the provisions of the Act. So it's well and good, for example, for the OTP to say all our departments are complying, but have they checked whether HRs in those departments, as when they recruit, comply? Have they checked whether supply chain and those examples? So I'm asking for a balance between taking this transition from establishment to establishing this data privacy, we as the supervisor and all of you as the implementers, to a point where the ordinary people start feeling that we are there and we are helping each other. So that was the principal point I made. Thanks.
Thank you very much.
Sorry, I think Mr. Gwala just had a comment.
I'm covered, but I think the last aspect that I wanted to deal with, the issue raised by the gambling, I suppose that the lady who comes from the gaming industry comes from the gambling board, which is a regulator. The only thing I can say is that as the information regulator, we've had excuses of that nature where somebody, WhatsApp is a very practical example, who would say, you don't have jurisdiction over me because I'm a company registered in the US, operating from Ireland. But we all know from the past, because even if this is a new phenomenon, but it links with the past, where if you have a multinational company that operates in various jurisdictions, you have to comply with the laws of the country that you operate from. So in this case, for example, the issue of Betway, even if it may be licensed in the Western Cape, it operates in South Africa as a whole. And all these gambling boards that are in these various provinces, I don't see why they can regulate. Because sometimes the Western Cape may be relaxing, or they have a different take on it, and they are not as vigorous in terms of regulating as, for example, Limpopo would want to do. So I'm saying, I think it's high time that we, as regulators, we put our foot down, because at the end of the day, it is the responsibility of the regulators to, as we have demonstrated with the WhatsApp issue, some of these terms and conditions, as regulators, we can actually contest those on behalf of society, and ensure that these organizations, they don't go away with murder, basically. Thank you.
Thank you very much. I mean, what's emerging and what's becoming increasingly clear is that there's a need for public-private partnerships to increase quite more significantly, and horizontal relationships between regulators, different regulators working on different topics. there is a collective approach that's needed. I'm bearing time in mind, but I'd like to go over to Mr. Mazibu to talk briefly about information security and what was discussed in his session, but particularly the overlooked area of physical documents. I think a lot of people confuse or ignore the actual physical documentation side of things and just think of cybersecurity. But we're living in a country where print is still a significant part of how we do business in both the public and private sector. So please go ahead.
Thank you very much. So in our session, the topic was security safeguards on and offline. Unfortunately, like the other groups, we were not able to tackle everything. We dealt with part of the online security safeguards, but even there, we spoke to some of the challenges that are faced by both the private and public sector, including small and micro enterprises. And we also spoke a bit about the guidance that we need to provide to responsible parties in assisting them to comply and, in essence, to help us to protect the personal information of data subjects. So because we didn't get to the offline part, I'd like to just start off there because if you look at the security safeguards, they encompass from Section 19 right down to Section 22 of the Act. And where we're talking about the technical and organizational measures, we need to also know that these measures that we put in place as responsible parties, we need to extend that to say the operators that are assisting us to process personal information also have comparable measures to us. I think that those are some things that we didn't get to. And if you look at the security standards that exist, they are usually split between both the logical security and the physical security. And that physical security now encompasses what we do with physical, maybe documents, and how we protect those physical assets that we have in our organizations. If we look at the filing cabinets, we go to a lot of responsible parties who still deal with paper-based information, collecting forms, and all these forms are usually kept in boxes, in storerooms, and people usually don't even know what is in those boxes. The access to those rooms is usually from anyone from cleaners to any person who can pick up a paper and start reading this information. And it's ignored because when we talk about security, oftentimes our mind diverts to the technical part, to the software tools and whatever we need to put in place technically to look at security. And I think it's a very overlooked part. And, it talks to the basic hygiene we all have in terms of looking at personal information that we process and how we just leave documents oftentimes on our desk. And it's something that we are not cognizant of in terms of the dangers that poses, but it's something that we need to always look at. So when we looked at the challenges, we found that there are some interpretation challenges on the wording of the Act in terms of understanding what reasonableness is. I think that was one of the questions that came up in our session in terms of what would be reasonable in terms of security measures. Chair came in at this point because it was very important to make the distinction and make, highlight that reasonable needs to be read with appropriate. So it's reasonable and appropriate measures that we need to put in place. And I think that challenge, came back to us in terms of why can't the regulator maybe prescribe what these reasonable measures are. And I think for us, the difficulty there is the danger of us finding ourselves being both the player and the referee, because once something happens, it will be very easy for responsible parties to come back and say, but regulator, you were the one who recommended these safeguards to us. Now we've had a compromise. You can't then hold us accountable. So it boils down generally to the uniqueness of the organizations that we find ourselves in. We don't process the same type of information. We don't have the same informational assets. Some organizations will be more cloud-based and all their assets are handled by someone else, where some will have on-premise servers and where they need to have tools for that. But if you go to organizations, especially in the public sector where a lot of outsourcing is done and private companies are used to deal with information security, we find replication in terms of the security policies that they have that don't necessarily talk to their implementations, but because the same company will be assisting, this is an example, the Office of the Premier, COGTA, and Department of Health, for example, you will find that the information security policies across these organizations are the same, but it doesn't talk to what they have implemented in those environments. So it becomes a very, box-ticking exercise, the box-ticking exercise where we have complied because we've got this policy. It talks to the standards and all the aspects are there. But when you look at the policy, it talks to security measures that are unnecessary because that is not what you have in your environment. And the response we get is that, no, we are just being proactive in case we start doing this. But it's obvious that it's just a generic policy that is out there. So when we got to the guidance aspect, we found that there's a realization that security awareness amongst the people in the organizations is very important. Now, we find that a lot of organizations that were in the room say that we do have posters that are put up, we do have these messages that go out to people in terms of how they should be protecting themselves. But in terms of monitoring that and ensuring that that actually happens, there is no follow-through in terms of maybe surveying the employees to see what they have learned from all those aspects. And so there was a suggestion that maybe we develop risk matrices for different levels of organizations where we would have a different risk matrix and expectations for companies that have a budget of 2 billion for cybersecurity vis-a-vis companies that are small and micro enterprises like our local Stockfells who won't have a budget to hire a cybersecurity professional. But the challenge there is, won't we be now setting a precedence where some people need to comply correctly and others, because they may not have that much money, the personal information they process, those data subjects can now be prejudiced. I think it's a very important question that we need to grapple with, and these are not questions that can come from, answers that can come from me, but maybe we can continue our engagements and see where it takes us. Thank you very much.
Perfect. So just to pick up on that last point, it's not common at all for regulators across the globe to set technical and organizational measures, to your point, because working with a lot of cybersecurity professionals, we know that they change every single day, maybe every single hour, whether it's encryption standards, whatever it may be. But we've come to the close of the session and we're about to head into lunch. I'd like to thank the facilitators and the participants who contributed to this section. We'll be having lunch at the restaurant, which is on that side. Lunch will be limited in terms of time to 45 minutes. I will ask that you please, both the people online with your TV lunch that you may be having, and the people in this room to please be back by just after, let's say, 2:05, and then we'll pick up the program going on with the journey in compliance with Dr. van der Walt and Ms. Ramoneta, and then we'll move on to the last session on innovation and accountability. Thank you very much.
Didn't even get to
Welcome, everyone. Welcome back from lunch. Good afternoon, everyone. Welcome back from lunch. I see quite a few of you are still wondering. I'm looking at someone in particular that seems to be wandering around the room. But the next session is going to fly by pretty quickly, the next two sessions. What we'll be looking at in particular are the best practices from the public and private sector on POPIA compliance. Now, I got a gentle suggestion from one of the speakers to say that this isn't a session focused on best practices, but rather their journey in complying with the Act. And I think that's a pretty astute way of looking at it, because this isn't a sort of POPIA isn't a fixed target that you can just achieve and then you're done. It's not a fixed line that you draw in the sand, but rather a journey. And so I'd like to invite from the private sector Dr. Pieter van der Walt from Discovery to share some of his private sector insights. And then from the public sector, I'd like to invite Ms. Sefagwane Ramoneta from the Department of Home Affairs to share the public sector perspective. What each of them will do is talk to you for 15 minutes about their compliance journeys, best practices, and then what we'll do is we'll spend another 15 minutes looking at questions and open up for discussion on these best practices, and we'll be sharing insights essentially on how to comply. So I'd like to hand over to Dr. van der Walt. Thank you.
Good afternoon, everybody, and Madam Chair, thank you for the opportunity and the invite. Really do appreciate it. As Nathan said, I'm going to give you a brief overview of our journey. It's not a recipe for success necessarily. It's not a template that you can just copy and paste and use that. Our risk profile, our requirements are different from, say, another company's. But within that, I hope to be able to, at the end, give you some steer insofar as things that we've learned over the couple of years that we've been driving privacy within our business. It's really been, like I said to the chair this morning, it's been an exciting journey. It's been an interesting journey, and it's been a career molding journey. And it's definitely something that we as Discovery would like to share with you as much as we can. I'm going to go through just briefly in terms of my agenda. There's some highlights in there. The slides are text heavy, but ultimately what I'm trying to do in this is also just to give you some of the high level things that we've gone through. I've tried to list as complete as I can possibly can, but inevitably, given the time constraint, there's not always that luxury to always have all of the detail that I can give through. But hopefully this will help also get the message through. Just some interesting stats that I've picked up in terms of preparing for this slide. 79% of countries globally are now supposedly covered by some privacy legislation. That's about 6.3 billion people that's under some protection laws. Of course, we all know it, AI, big data, digital platforms, you've spoken about social media platforms, are massive drivers for data currently, and we all express our concern insofar as the misuse, transborder flows, and all those type of concerns that we do share with everybody. Privacy is a multidisciplinary compliance effort. It's not just one or two teams or a team in the dark that sits there dreaming up policies. It's definitely a multidisciplinary effort. And what we've also seen in terms of our peers is privacy needs to be integrated into the business strategy. It's not something that stands on its own. And of course, all of this becomes what we do every day. Our philosophy around privacy, it's more substance over form. It's not just a tick box exercise. It literally takes a village of making a success of privacy within the organization. There's various roles, and I will elaborate on that a bit more later on as well. Contrary to popular belief, it's not an IT project. Unfortunately, we've seen with some of engagements that we've had externally as well, people think this is an IT project and IT will take care of the security. IT will take care of all of this. There's one condition really that takes up on the IT and security side within the Act. The rest are business. So we want to make sure that we understand business. You're accountable. You determine the purpose for collection, not IT. IT helps us with some of the plumbing, some of the controls, but that's to the extent of it. And ultimately, we want to make sure that from a values perspective, privacy aligns with our values as Discovery, and we align with privacy as well. So we've got a saying in our department, our overall Discovery mantra is to make people healthier and to enhance and protect their lives. We add digital into that conversation as well. It's not just your financial well-being and your health, but we also want to make sure from a digital perspective, we take care of that. So quite early on within our project, when we started rolling out our privacy compliance efforts around making sure that we comply with legislation, very how can I say, a heavy compliance focus. And as far as we wanted to make sure is that we start rolling this out across all of the business areas, given that there's different areas that focuses on particular diversified financials. We want to make sure that it's no longer just a compliance issue, but we want to embed privacy as a core business capability, and we want to make sure that that scales across the entire business. We built up a privacy office at the center that supports all our deputy information officers across the South African composite. Yes, and we also learned from our overseas colleagues who's gone through the GDPR journey as well. So ultimately, we wanted to make sure that we reuse what's already been put in place across our organization. Controls, impact assessments, there was some talk about DPIAs earlier on. We started that quite earlier as well to make sure that all of those reviews from an impact perspective is done with insights from security, risk, compliance, and so forth. And we want to make sure that from a continuous improvement perspective, that we also start following best practice. We are ISO 27001 certified, and recently, well, up to 2 years recently, we also did the ISO 27701 certification. It's not something that we brag about, but it's something that helps us to maintain processes and making sure that whatever we do from a security and a privacy perspective is done so in line with best practices. So what did it take? And it still takes. It's a never-ending journey as well. It's not a project that starts and ends off on a particular date. Strong executive sponsorship. That box is ticked, and I can assure you we've got the backing of an executive across the board. Distributed leadership network, so a deputy information office and various privacy champions across the group. And we collaborate. We talk to each other. We review incidents together. We learn from each other. We try to understand each other's challenges. We also appreciate that for some of our DIOs, it's not their full-time job. Smaller companies have a DIO role or a function, but they might be doing other things as well. Some other companies that are larger, full-time privacy officers that looks after their privacy within that particular context of that organization and their particular requirements. Enterprise-grade tooling. We also realized that from the beginning, trying to manage and operationalize privacy using Excel and email in a large organization is a non-starter. You cannot do that on those tools, however good they are. But from an operational perspective in a large organization, getting requests in, dealing with privacy rights requests, dealing with complaints, dealing with all sorts of requests, POPIA, etc., requires an enterprise type of platform that you need to put in place. Obviously, with all of this, we also try to make sure that it's properly integrated into our enterprise risk processes, cybersecurity, procurement, legal reviews, so that at least from a breaking down the walls, as it were, between functions, that we have visibility across the board as much as we possibly can when it comes to review of privacy activities. And then, of course, a robust governance and escalation practices, that's all in place. So there are forums, there are different governance bodies within the company that we help to maintain visibility, but also to make sure that whatever is decided and whatever is from a policy perspective is also driven from the top as well. Privacy by design, we've spoken about that earlier this morning as well. So from a privacy practitioner perspective, we know there's 7 principles around privacy by design as a standard. But we also wanted to make sure that when we start with our privacy initiatives, so any initiative that talks to processing of personal information within the business, that includes a natural person as well as a legal entity or a juristic entity. We do a DPIA. That is law, so all our PMs know that when they initiate a new project, we do a DPIA. That DPIA is filled in by the business. They then submit that for review to the necessary assurance partners, including security, compliance, risk, and if needed, we would then include ethics or other external SMEs as well. We've now recently also included our AI assessments into the process as well, because as we know, AI is a different or a new means of processing personal information. And of course, we're not perfect. There are still some tweaks that we have to comply and do to make sure that we understand what does it mean when we do training of models, when we do fine-tuning, or we do processing of personal information through those models as well. What is the ethics framework around that as well? Like I said earlier, our enterprise governance, it's totally aligned from a privacy by design perspective. So our security, cyber, legal, procurement, etc. There's key parts of those review cycles. From a culture and awareness perspective, we've got ongoing awareness initiatives, including today as well from a privacy, International Privacy Day perspective. So we've got our own initiative happening back at the office. And there's a change team that we have that looks at making sure that we also get this message out. And this is the kickstart of other privacy initiatives that we've got later on during the year as well. From a record-keeping perspective, this is quite key. If you don't have records of what you're processing, how are you going to explain to the regulator, auditors, etc.? What are you processing from a processing activity perspective? And what are your information assets? What are those information assets when it comes to data elements? All those things sort as outsourced to third parties, etc. Where does it happen? And what are the retention requirements from those activities that we also have under our purview? We're also now working to put in more workflow and integration and automation to improve our processes as well, because we do realize doing this manually is not feasible and sustainable. So helping to put privacy requests that we get from the public, we automate that into the workflows, we address those, and we provide that information back. We access governance, all of those things, we do make sure that it's from a workflow perspective is also better controlled. The ROPA, for those who don't know, it's a record of processing activity. That's on the same as what you have on Article 3. So we also like to borrow from other jurisdictions in terms of what their requirements are when it comes to best practice or frameworks that they have in place. So we want to make sure that our ROPA supports our DPIAs. So when we do a DPIA, we know the processing activity has been defined. We know what data is being processed. We know what systems are involved. And if that system is supplied or a third party is involved, we want to make sure from a contractual perspective, those things are also in place. Contract not signed, you can't proceed with this activity. And then, of course, there are things like security reviews, the due diligence that also happens. And we wanted to make sure that this platform that we've got grows with the business as well. We do understand and appreciate from business side that sometimes the governance process might stall or delay a product launch or a particular activity. So we insist that we do it from the start as soon as possible and that it doesn't become an afterthought and things might be more expensive to deploy or to fix once you've rolled out your initiative. Third-party risk management, quite a concern here insofar as third parties that process our information. We want to make sure that whatever third party that we engage with also complies with the necessary requirements from a security perspective, contractual, etc. So we do make use of our security officers that do due diligence on our third parties. We want to make sure that we continuously monitor those ones. But in a large organization, your capacity becomes a challenge. You only have so many people that can do a due diligence, etc. But ultimately, we want to make sure that we've got visibility from our high-risk vendors and third parties to make sure that they comply with security controls as well. That's where your breaches are more likely to occur than just making sure you've got security controls within your own environment. Incident and response, we had a chat earlier in the breakaway, and what we want to make sure is that from an incident perspective, that whatever happens, that we're ready for it as well. We want to make sure that we understand who's involved, so that when we call a crisis management meeting or incident breach meeting, that we make sure that we have our security teams, legal and compliance, public communications, etc. We've got all of those people on call should something happen. We might have the greatest privacy and security controls in place, but remember, sending an email to the incorrect individual is also a security compromise. And that could mean problems from a reputational perspective, definitely. We do meet regularly in terms of incidents that's been reported within the business. We review it as DIOs, we review it together. We want to make sure that we understand what is involved. We want to learn from those incidents. And we want to make sure that when we do respond, either by reporting to the regulator or saying, no, this is just an incident, it's not notifiable, or whatever the aspect is, that we come out of that clear understanding of why we said or decided it's a compromise or no, it's an incident. We also do some tabletop simulations just to make sure that should something happen and we understand where our potential gaps are so that we can make sure that we strengthen that response as well. Then we just wanted to finalize here on some of the security control side of things. Yes, we have the DLPs in place. Yes, we have good alignment between our cyber teams and our privacy functions. We also make sure, and being in a very heavily regulated environment, that we make sure that there's annual training, there's compulsory training from a privacy as well as security perspective, and especially in high-risk roles, where we need specific awareness around some of those people that handle very sensitive information, that they do so with the necessary care. And again, like I said, with the awareness campaigns, we do that also quite regularly, and making sure that everything that we decide across the business, there's a privacy element in there as well. So just quickly in summary, from a practical perspective, information officers and deputies, make sure you do appoint them. And we have also made sure that where we do appoint DIOs, that we also give them the necessary training. Not all of them have the necessary, understanding of the Act, so we try to make sure that when we appoint any DIOs, that they have the necessary training, what's expected from them, etc. Again, like I said, from a ROPA process, so it's record of processing activities, we want to suggest that you start off with something that is structured, easy to record, make sure that you understand what are your processing activities within the business, and start mapping that out through your DPIAs that you support those ROPAs as well. And then, of course, operators. Other than the due diligence from a contract enforcement perspective, make sure that there are contracts in place. Our biggest challenge when POPIA was put into action, we wanted to make sure that our third parties are also aligned. So when we also had to review all our contracts, but also importantly, when they do respond to RFIs or RFQs, part of the privacy due diligence, 2 questions that I look at. Where's your POPIA manual as a third party? Is your information officer registered? And I'm sure Tondo can see when there's a spike in information officer registrations, there's probably a discovery tender going out. And then, of course, from an incident response playbook perspective, be prepared when something does happen. Doesn't matter how big or small you are, be prepared if something happens. If it does happen, there's no finger pointing, there's clarity around roles, who communicates with the regulator, who communicates with law enforcement if necessary, et cetera, who reports. Do you need to invoke your cyber insurance? All those type of things that you need to make clear so that in that crisis moment, and it happens at the worst time possible, make sure that everybody is clear on exactly what they have to do. And then build on your champion networks within the organization. There are many opportunities for cultivating networks within a large organization to make sure that the friends that you have here, that you've built up those networks, to make sure that awareness is there, is consistent, and you do have operational support when you do need it. Then just quickly, in closing, so we see POPIA as a strategic enabler. It's no longer just a compliance exercise for us. It helps us to show to our data subjects that we are serious about privacy. Do we get it right every time? No, we don't. We have people in our organization, people make mistakes, so we have to also make sure that whatever happens, we manage that carefully, and we also show that we are serious about making privacy our responsibility as well. Strong governance and cross-functional collaboration is quite important. Who does what are the roles, and make sure that you also build on continuous improvement. POPIA is not an end, start and an end. It continues with the business as you grow as well. From a culture and culture perspective, make sure that your principles around privacy is also built into everyday behaviors, decisions, and project life cycles. Yes, we want to use AI to help manage our privacy operations as well. We want to understand how that also helps us to make sure that we do that properly, and at the same time to make sure that whatever happens within this AI space, we do so responsibly from a product perspective and the outcomes that we drive for our clients. And that's it from me. Thank you.
Good afternoon. I am here to make a presentation on our compliance journey as a public sector. I'm from the Department of Home Affairs. So my presentation is going to look at some of the processing of personal information that is handled by the department, and we're also going to talk about the journey towards compliance with POPIA and some of the challenges that we are faced with and our way forward, going forward in terms of improving our compliance. So in terms of my first slide, it was just to outline why is POPIA relevant for Home Affairs. we do process a lot of personal information as a department. All of you, I have your data. So from birth, when you decided to get married, we do have that data. For those that have passed on, we have that information as well. And the information that the department has, it goes back to 1800s. So we have about 340 million records in counting. So we are still generating as we go. So far, I think in a day, we are able to record about close to 5,000 births that had occurred in South Africa. So you can count, it's still in counting. We have multiple of million data of citizens. And also we have of non-citizens. So those that come into the country, when they're applying for their visas, we do collect personal information as well. We also have data for the officials and also for the service providers that would do business with the department. Like any other organization, we do have challenges. So we do have issues of identity fraud and also manipulation. We do try and find ways to safeguard the information that we have. We also have issues of unauthorized disclosure of information to people that are not supposed to have access to such information. And we do drive awarenesses around the implications of such within the department. So in my next slide, it was just to bring the amount of data that we are processing. We are authorized and mandated to do so, to collect, to store, and also use this personal information. So we do collect the birth. When you give birth, we do register the birth. We also register the death. We also do marriage. And in some cases where a birth record or an application was made, you may find errors. You are also allowed to come back to Home Affairs for amendment and correction of those records. We also have a legislation around the alterations. So we do find cases where people alter their sexes. We do have a legislation that allows us to change records based on that. We also do marriages according to the Marriage Act and also the Customary Act and also your civil union. We also collect, according to the Immigration Act and the Refugees Act, collect data from the foreigners that enter our country. So what we do have, those are the lot of data that we have. So we try by all means to keep it safe and comply with the POPIA requirements. So in terms of, I think this slide was just to show the kind of data that we have. So we'll have your name, surname, biometrics, and also your ID numbers. And for foreigners, we also collect information from their passports, those that come with passports. If not, we collect some of the data that they may have in relation to asylum seeking and also issues of refugee. And we also keep records of our employees and also the records from supply chain processes. So our journey towards compliance with POPIA started early in 2021. Immediately after POPIA became a legislation that we needed to comply with, the department issued a circular to the employees communicating measures that we are putting in place in terms of compliance, and we did outline those 8 conditions as outlined in the Act. And officials were trained around this. Also, we have issues where we do grant access to third parties, like the banks, for verification. So when you go to a bank to apply for something, they are going to verify your information with Home Affairs. So what we have in agreement with the banks is, as a third party to Home Affairs, I'm using a bank as an example. I know insurances, they also do that. We also have SASSA as well accessing the records. We have in agreement that they would have to protect the information that they collect from Home Affairs, and also, this word keep running, but we also want them to give, you must also give consent to the bank. So it's not automatic because you have access to Home Affairs. When you get to the third party, you must also give them a consent for them to access Home Affairs systems. So in 2023, we developed a privacy policy which describes the ways in which we collect, store and use, and also share and protect personal information. The very same year, we also did a compliance framework where we were talking about the safeguarding of personal information for clients, employees, and contracts, and also the issues of integrity and confidentiality in processing such information. So just around the issues of third party, you know, we are all coming from a family. So my birth record as a child, I'm a child to my parents. There are limited number of people who can access a birth certificate of a child. It's not everybody. So we went through a process of identifying who has access to what in Home Affairs. So in terms of a birth record, it will be a parent and a legal guardian and also a next of kin. And then in terms of an ID document, so a parent applying for a 16-year-old, they would have access to such information. A spouse, to an extent, can come and request for an ID in an event, maybe the partner has passed or they are looking for certain information around that. We do that. But also, in some instances, we also request consent from the person who is granting you permission to come and collect an ID, for an example, for them. So marriage certificate, it's only the spouses, the children, and any other person who is granted as per the court order. It's not everyone who would have access to such. In terms of a death record, it's the spouse, children, the parents of the spouses of a parent, if the parent is the one who has passed, can have access to that. In an event where both the spouses have passed, the parents can come and request a death certificate, but we will have to verify the linkages between the families there. And so in terms of the visas and the permit records, we talk about spouse, children, and parents. And then in terms of employee and service providers, here we share records as per the relevant DPSA and Treasury regulations. If not, we do not share such information as long as we don't have a clear understanding. So in terms of our journey continuing with compliance, what we had done was we developed a consent form and also piloted it. So the consent form was for a client. When you walk into Home Affairs, at some point you are going to be requested to give a consent that I am leaving my personal information with Home Affairs. Home Affairs will safeguard the information, will share it with third parties for your benefit. That will be issues of SASSA and issues of banks, so that you are able to access other services. That's why I said when you get to the bank or to the service provider, you still need to give consent of that. So we did pilot in 9 provinces. So we selected 18 offices and also 9 healthcare facilities where Home Affairs has an office. And the pilot, I think it ended in 2024. And we are currently in the process of finalizing the approval for that consent. I think it has been approved. one of the officers, what they did in Bloemfontein was, even after the pilot, they are still continuing to use that consent form in the attempts to try and comply with POPIA. So in terms of other compliance issues, so internal audit said to us in 2024, you have been implementing POPIA since 2021. We want to do a test of the process and see what are the things that we can improve on. So one of the findings that they had, there was the issue that we did not have appointed deputy information officers, and we had not registered with the information regulator. And from there, when internal audit was busy with the audit, we were already in a process of doing a POPIA maturity assessment across the department. So the approach that we took was we selected, so head office, it was a must. We selected 2 or 4, I think 4 offices in each province where we would go and educate them on POPIA and show them the model and allow them to do a little bit of a self-assessment. And we also did phase 2 in 2025 where we went to the 7 provinces and the 5 refugee centers that we have in the country. What we did in 2025, we did invite information regulator. We were launching what we call POPIA Champion. So what the DG did was, because he is by his nature of the job, he is the information officer. He appointed all his deputies, deputy director generals, to become the deputy information officers, and also the provincial managers, all 9 of them, they are appointed as deputy information officers. He also appointed 60 officials across the department to be POPIA champions in their area of work or in the office where they are based, so that they are able to champion POPIA on his behalf in the day-to-day implementation. So finally, in July, we did register, but we registered the information officer and 1 deputy information regulator. That would be Mr. Mavoso, because he is the one championing the operations of the department. And what we did later was for us to approve that consent form. So we do have the consent form that is approved. We've also developed the standard operating procedures for POPIA. They were all approved in November 2025. And what we also do is constantly we do give awareness sessions to the officials, just for them to try and improve in terms of compliance. The challenges that we are faced with as an institution, it's lack of capacity. As a department, we don't have a unit that is dedicated to drive a compliance with legislations, whether it's POPIA or PAIA. So you will find issues are scattered around. For example, POPIA is driven under Enterprise Project Management Office with legal services, and you have PAIA processes sitting at legal services. So we don't have dedicated officials that are looking for POPIA on a day-to-day basis. We have, the other challenge is that we are unable to cover the full footprint of the department. We select, so for now, all that we have done is not done entirely in all the offices. We have been sampling because we don't have, I think it's only 3 of us that are doing POPIA at national. So, and we are not only focused on POPIA. So we have legal services, the person is also responsible for drafting legislation, and then you have myself also running the project management office together with Mr. Mtiani, who is also the policy, responsible for policy within the department. So that limited resource, it's really giving us a slow pace in terms of the impact that we want to do around POPIA. We have not yet fully institutionalized it, but we are finding steps towards that. The way forward here, what we are currently doing is the department is going through transformation. Let me put it as transformation, because we have digital transformation. Our minister, every time he speaks about digital transformation, moving home affairs. So now we have home affairs at home, where you can, it's coming, where you can apply at home and get your ID delivered at home. We are working on that as a department. As a result, it means Home Affairs is becoming now going to be, IT is going to be at the center of everything at Home Affairs. So that means a lot of changes are happening internally. We are also reviewing the structure, where we have at least included the compliance office, hoping that DPSA would approve and agree with how we have put the structure. What we are looking forward to do is now have a training program for the entire organization around the consent form and also the operating procedures. And we would like to institutionalize that maturity model in all offices, so that managers can do a self-assessment at least twice a year, just for them to see whether they are still on the right track with implementing the POPIA principles that we have as a department. It is a journey, but we are looking forward to the future. Thank you very much.
Thank you very much. Sorted. I now invite questions from the public and private sector related to any of the topics discussed that you may have. Are there any questions? And the crowd goes wild. Okay, there's a question on the right-hand side.
No, thank you very much for this opportunity, and good afternoon. Yeah, my question is directed to Home Affairs. I just want to check with you with regard to what you have mentioned in your presentation. You said, as the department, we are confronted with manipulations, corruptions, and fraud. So I just want to check with you, how are you dealing with those challenges that you have outlined? What measures are you putting in place in order to mitigate such? Thank you.
Okay, before we actually take that question, I just want to check if there are any other questions. Okay, in the middle over here. I would say that we want to limit the questions to the topics that we're discussing today. Please go ahead.
There we go. I have one question for each of the panelists. I found both presentations fascinating. So the first one is for Dr. van der Walt, and based on your presentation, I have to say that Discovery does instill trust in, at least for me, in how you deal with the masses of information you deal with, I assume, for all your different products across different departments, etc. And I was especially taken by the extra measures around third-party processing agreements, and then you mentioned identifying high-risk third-party groups and, monitoring those in a bit more detail. So I'm just curious, so what determines who is a high-risk group? I mean, I assume it's based on the type or extent or purpose of the data that they process, and not necessarily because Discovery feels that they're contracting with someone that they don't entirely trust. But that's just a curiosity question. And then I do have another question for the lovely information regulator from the Department of Home Affairs. So you mentioned that we register many births in South Africa every day, and this does relate to the question that I want to ask. So we also know in South Africa we have a massive backlog in birth registration, especially when it comes to children who've been abandoned or like children of foreign nationals where the birth certificate isn't, you know, citizenship, anything like that. It just records that they exist. So something that I'm wondering is whether the information officer side of the Department of Home Affairs interacts with the legislating side of Home Affairs when they look at reviewing legislation, etc. Because to me, I feel like there's a gap in legislation or regulation on birth registration, but of course, it's on the other hand, it's useful for the information, like information processing to have that information. So I guess I'm just curious about the interaction between the two divisions.
Thank you. And then I see there was one last person. Okay.
Yes, thank you very much. So my name is Jabo, and I'm from the CSIR. Dr. Van der Waal, just on your end, very impressive in terms of what we have shown. I just want to, maybe if you could share with us, how do you drive the culture within Discovery? Because it seems like there's a lot that you are doing, but also, you know, touching on what Ramoneta was saying about the lack of capacity at Home Affairs. What is your capacity looking like? Because I just want to get a sense with regards to your capacity, particularly as a private body. And then, Ms. Ramoneta, obviously you did indicate that there's issues of capacity. So I just now want to get a sense from a risk and threat perspective, particularly because I'm assuming you have, as you have said, 340 million of our data, and there's no dedicated office to actually deal with this. What is the risk of that, and what are we doing, you know, to actually ensure that some of this data is safeguarded? But thank you for the efforts so far. Thank you.
Perfect. Are we just going to take the final question and then we'll hand over to our speakers?
Oh, thank you, Chair. Good afternoon, colleagues. Lindwe Magazi from Limpopo Office of the Premier. My question is for Mayor Ramoneta. I'm a public servant, so I'm really interested in this one. You spoke about POPIA maturity assessment, and I wanted to know the dimensions you measured and how many levels of maturity you were looking at when you were conducting your maturity assessment. And if possible, can you please share your template with us so that we can implement it as a province? Thank you.
Okay, let's start with Peter. Please go ahead.
So with regards to the third parties, so under FICA, with some of the financial disclosures that we have to also make sure that we declare material outsources. So that's a legislative requirement. That's something that we have to do. So especially where there's big engagement with external suppliers, that we have to declare that. So that's the one principle. The others are where we look at sensitive information. So if you look at the special categories of information or the special health type of biometrics, etc., we'll take that into account. We'll also take the volumes. We'll also look at, are we going to integrate with that third party? Is the integration necessary? Because that would obviously increase the requirements from a due diligence perspective, etc. So we'll look at all of those factors and take a decision around what is our dependency on this? Is it a long-term relationship? Is it a short-term relationship? Other factors such as, is it offshore? Is it within country, etc. Very often there might be a back-to-back integration with cloud services that we also have to take into account. That's where our security teams come in, and they would do a proper due diligence. And if they're not happy and satisfied, we say until you've fixed what we found, we might not even proceed on that particular arrangement. So we'll always look at in our environment first, in country, and then obviously look at what are the options going further. But there are legislated requirements that we have to do from a declaration of material outsourcing, and then we'll also look at the type of data, the type of supplier, etc. Obviously, commercials come into the conversation as well, but that gets handled through the procurement team. They will pull us in from a due diligence, privacy and security to say, are you happy? Have you looked at privacy policies, contracts, etc.? That will also be done. Okay. And then from a capacity perspective, I've got my laptop here. It's working, so that's my other half that I rely on to do most of my work as well. But from a change perspective, we have, in our team, we have a dedicated change manager that helps us to drive messaging within the business for all our new projects. We also then rely on the communications team across the business to help us drive the message consistently and within the confines of our corporate identity as well. And ultimately, when we do an initiative, I would rely on my DIOs to drive that initiative within that particular business. They are then accountable for driving a change or a call to action of some sorts into the business using their own resourcing as well. So my office, it's me and my DIOs across the business, and then I've got access into platform side of things, so services provisioning there. But ultimately, it's very small, and it's a reliance mostly on specific functions and specialities within the business that we rely on. Yeah.
Okay, thank you for that. In terms of issues of corruption, I think Home Affairs is the only department that has a unit that is called counter-corruption, and it's headed by a Deputy Director General. That unit does issues around, they do evaluations of the processes to identify weaknesses of potential manipulation and fraud areas within the department. I think they do close to 4 in a year, or 16 in a year, I think, just for them to assess and see where are the potential areas where we would have weaknesses of corruption there. And also they are also driving investigations. So if you do identify a Home Affairs official who is doing corrupt activities, you can liaison with that unit. They would do an investigation. And I think you have been seeing a lot of arrests and a lot of stories about Home Affairs officials that have been arrested or have been criminally charged around corruption. It's because of that unit called counter-corruption within the department. So we do find, we do have mechanisms to try and reduce corruptions and manipulation issues. In terms of the issues around late registration of birth. So we do acknowledge that we do have South Africans who have not, were not able to even register the births of the older generation. So it's a generational, in most cases you find it to become a generational issue where a grandmother did not have an ID. Subsequently, her kids will not have IDs and their children will not be able to register. So what we do is, in the nearest office, you can go plead your case to say, I am a South African, here are the people who can witness that I am a South African, have evidence to support your case. What the office would do is they would take that application, they have a committee within a province, they would sit and assess the evidence. Where we are not comfortable, we do send a counter-corruption to still go and do an investigation of whether truly this person is a South African. So we would go find the witnesses that you had put forward, and we would interview them to make sure that really the case is a late registration of birth, which I think the cause of this, it's also the issues around when a mother goes to a hospital to give birth, we tend to leave our IDs behind, and it becomes a problem. The law says you must register your child within 30 days after birth. So you miss that 30 days, now you have to pull evidence into the play for you to register your child. It becomes a late registration of birth. And we have a lot of those cases where people come to the hospital without an ID, especially in hospitals where Home Affairs has an office. You are able to even leave the hospital already had registered a birth. The only thing maybe you might not have got the certificate. In most cases, I think people do even receive the certificate before they even leave the hospital. So it's a matter of us changing the perspective as South Africans in order for us to make the job of Home Affairs a little bit easier in terms of us documenting every child and every citizen in the country. So in terms of the risk and threats, what we are currently doing, Home Affairs is currently having a project on digitization of records, and the 340 million records I was talking about, it's only for citizens. I have not yet touched the foreign records, so I don't know how much records we have when you include immigration records. So in terms of the citizens' record, the President has pronounced on the digitization of records project. We are currently running that project. We are digitizing records. I think since 2023, we have digitized about 65 million of those records. And what we are doing is we would like for the offices, when you go to the local office, when you go and apply maybe for an amendment, we reduce that lengthy waiting period. Once we digitize most of the records, when you go to an office to amend, the office is supposed to access your record electronically. So the risk here is, the problem is currently the systems, we have not done a lot. If I go myself now, I think I checked my record a few weeks back, they had not yet digitized my birth record. So if your birth record is not digitized, you still have to go. If you apply in Polokwane, you apply to do an amendment, it must go to head office. Your record is kept in Pretoria. Imagine us going through those files, trying to find that. It takes longer. So we are trying to minimize that with digitization of record. So in terms of the threat issues, what we do is we have a risk management unit that works hand in hand with us in terms of identifying potential risks and threats that may be faced by the department, especially even around POPIA issues. So in terms of the maturity assessment, my colleague, I don't have a problem to share the template. What we have done is we had identified 5 levels, and they range from initial where you are being reactive to a point where you are becoming optimized at a 5. And we were looking about 12 areas. So they include governance issues, they include the culture within the organization, whether by designing your systems, are you considering privacy, and also the issues around security of your records or any information that you are keeping as an institution. So it's a variety of things that we were assessing. I think I've covered all the questions. Thank you.
Perfect. Thank you very much to our speakers and the people who asked questions in the audience. We have now concluded the session. So our final session focuses on innovation and accountability. And before we actually bring those speakers up, what I do want to mention is that if you noticed, we started out the program with a great address from the chair on the context for today's session. We looked at why privacy matters. We looked at compliance in practice and what the best practices look like, or journeys that were mentioned now. And so next, it makes sense that we look forward to the present. Well, we look at the present, but also the future. And so I'd like to call up Dr. Jabu Msweni from the CSIR, who will be talking to us about AI and data protection and risk management within that context. And then also Mr. Tandolo Yaba, the CIO from the Information Regulator. So while our speakers are coming up to talk, if you do have any questions, please write them down, note them as we go along, and then we'll address them towards the end of their sessions. Thanks. Okay, there are mics. Dr. Jabu, will you come in? Okay, perfect.
Good afternoon. Are you still awake? No, thank you for the invitation. I will try and be brief because I know it's been a long day. So I was given this topic, so it did not come from me. They said I must speak about AI for data protection and risk management. But as I was preparing, I thought I need to give a true account of what I see as the pathways for using AI in data protection. So as you can see there, I added the part that says the two sides. Normally, before I start, I like to always give a disclaimer. And when I came this morning here, I saw there were a lot of legal people. So I said, Jabu, you must be very careful because you might end up in court. So the views that I express normally in these presentations are that of my own. They are not of CSIR or of the Information Regulator. They are not controversial views. And also, you will see in the presentation, there will be a lot of graphs. Some of them I've generated, some of them are not necessarily mine. But the presentation is available for sharing. But please know that only for non-commercial purposes, for educational purposes, we can share it. Now, let's just maybe set the scene. Throughout the day when we were talking, I always like this quote, and it comes from Sun Tzu. So Sun Tzu puts it in simple terms, where he says, if you know the enemy and you know yourself, you don't need to worry about any results of 100 battles. In other words, you can go to any war, you will still survive. And you will get the context of why I put this. But he continues to say that if you only know yourself, but not the enemy, for every victory that you gain, you will also suffer defeat. And generally, this is what happens when it comes to even protecting data. People may only try to understand the data that they have, but not understand who is after this data, what do they want to do with this data, where is this data stored, who is using it, who is processing it, and the likes. And then he says, if you know neither the enemy nor yourself, you will succumb in every battle. Now, generally, this is what happens in the space of security. I'm a security expert, not necessarily a data security expert. But I thought I must also share with you, as I'm setting the scene, some of the things that they might give you a sense of why I gave you that quote. Now, if you look at this graph just shows the interest. Now, this is South Africa interest. How much people are interested or pay attention. For example, in this case, I just chose POPIA and POPIA. So, but it's over time. I think this is over 5 years. So you would see, for instance, I think in that spike, that's when the law was probably saying, now you must come and comply, and if you don't comply, you are going to be fined, so on and so forth. And then organizations and people, that's when they start to take data protection seriously. But immediately after that, then there's this lull there, or a drop, so if you kind of look at it. And what does this say is that people tend to want to protect data based on the law. But I think that's sort of like a very incorrect approach, and we will talk about that just now. Now, if you look at this one, it's a graph that shows you, I just chose some keywords there. I think it's data protection, information privacy, but I thought because I was expected to come here and talk about AI, let me add artificial intelligence so that you can see the interest. The green line on top there is AI. So people see AI as more important or as more interesting than data protection and the others. Obviously, we have a problem. That is why I'm saying if we don't know ourselves, we are going to have a challenge. And I will show later that compliance is okay, but compliance is not security. Compliance is not necessarily data protection. You need to do more than just complying, because the law cannot tell us everything. If we only follow the law, we are only going to protect the data only when the law is in front of us. And that is why some of the other things are also cultural. Now, and then I said, it's also important to look at where we are as a country, because that plays a very big role in terms of how we actually understand some of these laws. So if you look, for example, into this slide, when it comes to AI in Africa, Oxford Insight says we are number 2. I'm not sure, though, but it says globally we are 67. And the one that is a worry is the one that we are ranked number 32 out of 54 in terms of dealing with data breaches. Now, this is like at the South African level. This is obviously a big problem, because it means when our data is breached as organizations, it takes us probably more time to respond, because we don't have incident response guidelines or roadmaps or something like that. And then in terms of cyber security index, we are about 59 out of 93. Of course, if this was the results at the metric, they are good, but this one is just the opposite, right? So it means the percentage is lower, okay? And then, of course, I'm just going to jump to the other one. When you look at the bottom in terms of the data theft, and I think Sabric does this a lot, where data theft has increased by 400% between 2023 and 2024. Fraud cases, the identity theft, and the likes, which obviously leads to a lot of commercial losses. For example, those numbers that are shown there, I think they're just underestimated. Sabric says about 1 billion losses in digital fraud, where they steal our data almost on regular basis. On regular basis, our data is being stolen, right? And it says there's about 50 million. I know in the morning we were speaking that cybersecurity is expensive, but somebody I think also mentioned, I'm not sure, but not having it is even more expensive, because you are going to spend almost 50 million, depending obviously on the size of your business, when you lose data. Plus here, we are counting, if the information regulator comes, that money might even be bigger if you get fines and stuff like that. So what it means is we need to know where we are. Now, here you obviously, I don't know how accurate the data is, but because it's based on just the media reports. But looking at just the reporting over the past, maybe let's say 3 financial years, 2022 to 2023, I think the reportings, again, this is just reported incidences, people who report, because there are many who don't, you know. I think it was around 500. But if you look last year, or the last financial year rather, it was almost 2,000, it's over 2,300. In terms of now, people who are reporting incidences of data breaches. Now, what does this tell us? It's either the law is good or something is wrong, because it also tells us what was happening when people were not reporting, how much of our data is not there. The impact of this is very, very high. And if you look at that, it says almost about 190, but the people from Information Regulator, they will tell me if it's correct. They say about 190 or so on average security or data breaches that are reported. Obviously, they will differ in scale and size, but they're about 190, okay? And if you check, these are the big ones. But the one of TransUnion, for example, it can also lead to multiples one, because I think TransUnion and MasterDeed, if all of our data are there, you know, that data, it can find its way in many, many other people, and it continuously get compromised day by day. But that's about 54 million records. That's almost the whole country in our context. And that's a very big problem, because once that data is out there, it's even very difficult to even protect it, in all honesty. It's very, very, very difficult. And then we have others that are mentioned there. And maybe the other misnomer, which I normally hear a lot, sometimes we will say it's only the government or the public sector that is a problem. But at least based on what I've seen, is that this problem cuts across. It does not discriminate. It really cuts across. Now, there are also, and I don't know how this is normally dealt with because it might not always be a POPIA violation problem. Data breaches, they happen in many, many other ways, particularly from personal information. And one of the key issues is stolen credentials. I don't know how many people, for example, on a regular basis, they share, employment opportunities with people, but those employment opportunities are actually fake, right? Where somebody says they're Transnet, whoever is hiring, but the link is pointing somewhere. People send their IDs, they send their CVs, and so on and so forth. That's data compromise, but I don't know then who is held responsible there because it's Jabu who sent this CV and the likes. So there's quite a lot of those. If now with NSFAS and the likes, and I think the colleague from Home Affairs who was speaking here was thinking there's a scam currently about people setting up a website where they want you to book maybe an appointment online. Let's say maybe you want a passport or something like that. They've set it up and it is running. So when you give your information, you give it to the wrong person and you think you are giving it to Home Affairs. A big problem. But the question is, who is responsible for such? It's still not so clear because Home Affairs will say, that is not our website. You went to a scam website, but your data at that time, it is gone. And then, of course, phishing is quite a lot, business email compromise, and then, obviously, the supply chain. Now, obviously, I was asked to speak about AI, but I thought it's also very important for us, before we talk about AI, that AI is not a panacea. AI is not the all in everything. It also comes with its challenges, particularly when we want now to look at the law itself. For instance, when it comes to AI, before we use it, and I think Dr. Van der Walt did speak about it in his context in terms of what the organization is doing, so that when they implement it, they don't just say it's AI, then they put it there, because it comes with its own risks. For example, data leakages. AI, you might use it, let's say, to process the information, but it can be a source of leakage of that data. Because sometimes, especially if you are using AI solutions that are foreign, just to give you an example, it may take that data and leak it as well. But AI can also have a problem of over-collection of data, where you might be putting it in your system, but now it overly collects and it overly processes, which is obviously against the principles that are there in POPIA and the others. But of course, the other challenge that we have, especially if we are not in control of these AI solutions, is lack of explainability. Sometimes it can't explain. In other words, the openness part then falls away because it can't explain how it actually processed this data, where is this data stored, how did it actually arrive to the answers that it arrives to, and so on and so forth. So those are just some of the risks that are there. But also, one of the very big risks when it comes to AI, particularly when the data is anonymized, is that because it uses even data that is external, it can even re-identify some data sets that are not supposed to be re-identified. For example, issues of age or ID numbers and the likes. And then, obviously, we need to worry about the cross-border transfers and issues such as that. Of course, all of this, and I like what Dr. Van der Walt was saying, is that all of these things are contextual. In your organization, you just can't take it and plug it in. You have to look at it from the privacy perspective. You have to look at it from the security risks perspective, but you also have to look at it from the compliance perspective, because sometimes AI comes in. Maybe let's take an example of Home Affairs. They don't have capacity. It can assist maybe in making sure that some of the other aspects are done. But on the opposite, it can also create even more risks or get them more into trouble. And I just want to then get to this part before, because I know we don't have time. Now, when we look at AI, and some of these might not be in the correct order, but I thought from the POPIA 8 conditions, it's important that whatever AI solutions that we want to implement for data protection and risk management, there must be some mapping that is done against these principles. I've already, for example, touched a bit on some of them, especially when it comes to processing limitations, because sometimes we give our data and it ends up being processed for something different. And AI is a big culprit on that. And we have seen, for example, how Grok and the others, they're given information, but they end up, doing things that it's sort of like we can say AI has gone mad, so to speak. And with data, it's a big risk because once that data is leaked, it's very difficult to now say, I'm going to take it back and use it. It's like spilled water. You are going to have a big problem. But the security safeguards are very, very important. Information quality when it comes to AI is also very critical because once the information is not of good quality, it then leads to other challenges, for example, such as issues of bias, discrimination, and the likes, which we obviously, as organizations, we need to guard against. And I'm sure, Dr. van der Walt, at Discovery, that is very, very important, especially for us who are gymming. And then one thing I want to say, and we have spoken a lot this morning, and I tend to use this slide, is that whatever solution that we can think of, for example, AI, it's always important that these three pillars must be in place. I use this bank stool, we call it, because it's got 3 legs. If one of these legs is broken, that chair is going to fall. And what do I mean? Sometimes you could have nice policies, put processes in place, but if you don't have enablers, for example, technology, and you don't have people, I can tell you, you are skating on borrowed ground, because what's going to happen, you'll have policies, but you might also have issues internally where, for example, even insiders, they steal this information. And I've seen some of these things, they happen. You might have the technology, but if you don't have the people, it's also a problem. So the success factor says you need to ensure that these 3 work in sync. So technology, in this case AI, is obviously something we cannot avoid, but it cannot operate on its own. It requires processes, it requires making sure that at least we understand what we're using it for, and the likes. But, of course, it's not all doom and gloom. There are various use cases. I just don't have time to share all of them, where we could actually use AI for data protection. There are various use cases. And I think even in our session about security, we spoke about this earlier. The issue of automated data discovery is very important because I always say it's always very difficult to protect what you don't know. If you don't know where your data is and you don't know where your assets are, chances of protecting them are highly unlikely, highly unlikely. And that's sometimes where many organizations falter. They don't know where the data is, and because it's collected manually, it's collected in various ways by different people, different systems, and then you don't even know when that data has been stolen. And that's why normally research says organizations tend to find out almost a year later that they have been breached, almost 235 days later. And by that time, it's too late, okay? And then obviously, I think they spoke about privacy impact assessment, but one of the other important aspects when it comes to AI is the issue of real-time threat detection. Because if you can't detect some of these threats immediately with regards to the data that you have, who is actually using this data, including sometimes service providers, they come into our environments, they can use this data. I've seen, for example, in some organizations, people will be sharing, let's say, spreadsheets. This spreadsheet might be having customer data, it might be having salary information or people's information, and this data is shared without even managing the copy. Where's the original copy going to be? And a few years later, the data has been leaked and it's a problem. And I think if you look at one of the data breaches, I'm not sure whether it's Experian or something like that, something similar that happened where somebody came with a memory stick or a hard drive, collected the data, and we have a big problem. All our data is now out there. There's various others, but I'm not going to, I think I'm going to end very shortly. It's also, and I think Dr. van der Walt spoke about this, privacy must be part of the design. It must be inculcated into the culture. If it's by the way, unfortunately, you're only going to think about it when the information regulator comes, and by that time, it's too late. It's like audit. You can't do it. It must be something that is part of the culture, part of the business strategy. But when we are using AI, human oversight is also important. We can't only rely on automated data protection. The human oversight is important. Why? Because AI can still hallucinate and they can still do a lot of other issues because they are still being trained. Continuous monitoring, very, very important, particularly when it comes to issues of compliance, but also when it comes to issues of alert systems. That's very, very important. I think the issues of staff training they've spoken about. And I think I normally show this slide as I close, is that sometimes people focus on compliance, but compliance is not equal to security. Let me give you an example with this one. You see, in this case, the law at that time, and I think in South Africa, we almost had something similar. The law says the scooter driver must wear the helmet. It didn't say much about the passenger at the time, right? And then what happens is this lady they are not breaking the law, but there's a big problem here. If this scooter falls, this lady is in trouble. So it's almost the same with POPIA and others. Don't just do a tick box exercise. Make sure that you do way and above more, because AI on its own is not going to help. But I think it's also, people have spoken about this, the culture issue is very, very important. Because without that culture of ensuring that we protect our data, how we deal with it on a regular basis, you can put AI, but the culture will almost be the same, okay? And then the issue of due diligence at all stages. There's one thing that criminals always take advantage on is our lack of awareness when it comes to how we use technology and the like. So it's very important that at every stage we do due diligence and we don't necessarily trust, even if it's AI. It's important because I assume the reason we have this law is because our information is sovereign. If our information is gone, technically your identity and everything is gone. Thank you very much. I think I will stop here.
Thank you very much. I think we were about to get security to assist you out there. Just kidding. But next we'll go on to Mr. Tandolo Yabo, who will deal with systems that seek to improve privacy. CIO at the Information Regulator. Please go ahead.
Good afternoon, everyone. I hope we are all still awake. All right, so today I'll be talking about systems that seek to improve privacy. I think that's under the theme of innovation and accountability. And I think as we mark 12 years of POPIA, that's the right moment to ask some hard questions, and one of those being, are systems actually improving privacy outcomes, or are we just being compliant on paper? All right. When we talk about systems that seek to improve privacy, we're not only talking about technology. We're talking about the full ecosystem that makes privacy real. I think that includes things like law, it includes organizational accountability, it includes digital platforms, and all of those tools that help us, not just us, but organizations and individuals make better privacy decisions. This day, the International Data Privacy Day, I think it gives us space to reflect, but reflection alone is not enough. The main question here is whether these systems make privacy easier to do right. I'll try and go quicker. I know I'm standing between you and going home. So POPIA, I think, gave us a very strong legal foundation, but laws alone don't protect people. Protection happens when compliance is practical, when accountability is accessible, and when individuals can actually access and exercise their rights. From our side as a regulator, I think the protection also requires visibility and reliable data, and that's where systems matter. I think over the past few years as the regulator, we've deliberately shifted away from paper-based and form-driven processes to digital systems that try to operationalize POPIA. A core principle behind this shift that we've started is privacy by design. I know this has been mentioned quite a number of times today. In practice, it means that we do not treat privacy as an afterthought or a manual add-on at the end. We need to embed it. We need to embed POPIA requirements directly into our workflows. So we try and reduce the friction for organizations that really do want to comply and make non-compliance more visible and measurable. And you'll see examples of this a little bit later on in my presentation. And just as importantly, we need to ensure that the data we collect as a regulator ourselves is protected and purpose limited. So our e-services portal is central to this approach that we've taken. The next few slides, I'll give you some examples of the systems that we've put in place to try and improve privacy, and I'll start off with the registration of information officers. I think privacy protection starts with accountability. I think we all know as well that POPIA requires that every organization must designate and register an information officer with the regulator, and it is not and should not be a tick box exercise. It's been mentioned as well a few times here today. This creates a named individual that's responsible for compliance, a clear point of contact for data subjects, and it also gives a live obligation to keep all of the information up to date that is kept by that organization. All right, this is just an example. So these are the options that we've got available on our website. You can do a new registration. You can use the My Organizations option to ensure that the information that is with the regulator is always updated. We offer other services like name changes when there's a need. You can deregister. And on the right-hand side, we've got an example of our certificate that we issue at the end of the registration process. You'll notice that it's got a QR code at the bottom, and that can be used by anyone who wants to verify if the certificate is legit or not by just scanning that code with your phone, and it will present you the information that we have at the regulator about that organization. One of the biggest challenges that we've seen is that many organizations want to comply, but they don't know where to start. And to try and address that, we've introduced an online self-assessment tool for POPIA that is based on the 8 conditions. It's open to any organization, so any organization can just log in and start taking this self-assessment. We've structured it and designed it to try and identify gaps and risks that may exist in your environment. I just need to state that this is not an enforcement tool. This particular function is not an enforcement tool, and we do not use the results for compliance checks. It's just it exists for guidance and not for policing. Moving on to empowering individuals. So privacy is not only an organizational issue. Individuals also play a significant role in protecting their personal information and the personal information that they hold that may belong to others. So we introduced what we call the Personal Privacy Score on the e-services portal, and it's designed to shift privacy from theory to everyday behavior. So we assess practical things like your online behavior, social media usage, information sharing, device security, and other categories. And at the end of this, it's another self-assessment. At the end of the self-assessment, you get a score, but with this score, you also get guidance on what to do to improve. We've got a short course as well that comes with it that covers all of the topics that are in their self-assessment, and you can take that and maybe come back later to see if your score is improving over time. This is just an example of what it looks like. So on the left-hand side, it shows the score, it shows some guidance, and at the bottom, there would be all of the last 5 scores that you got while doing the assessment. And on the right-hand side, we've got the short course that we offer, different modules, and we track these. So once you're done with a module, we mark it as complete, but you can redo it if you want to, so that it sort of acts like a bookmark, so that you know where you ended and you can then just follow and complete the entire course. It's still basic. We are working on it. I will still continue to make it better, and hopefully one of these days we'll be able to put AI behind it so that we get better and individualized guidance based on your level of compliance. Sorry, I did not move on to the next screen, but that's what it looks like. Moving on to security compromises, and that's been mentioned quite a number of times again. I think we can all agree that this is no longer hypothetical. It's part of the digital economy that we operate in these days. POPIA requires that every breach be reported to the regulator, but I don't think all of them are being reported. We now have an online tool, which might be the reason why the numbers have started going up, but we've got an online tool now that allows organizations to report these breaches online. And this is just some stats that we've been able to pull from the submissions that we got. We went live with this, I think, in April last year, so it's been running for less than a year. And so far, we've received, I think, about 2,600 reports, and we're able to see different things, or we're able to draw up different stats from that. For an example, on that page, I've shown you that about 88% of the matters affect less than 10 people. The matters that have been reported to us, and on the other side, we've got 10 of them affecting more than 10,000 people. On the right-hand side of my screen, we do some breakdowns as well, so we can see which industries are most affected. In this case, the financial services industry is at more than 60% of the reports that we get, and we do other breakdowns by province, and in this case, Gauteng taking the huge, I think. Sorry, I'm looking at my screen and thinking that it is moving there as well. So yeah, that's the screen that I'm talking about. It's just some snippets of the stats that we draw up from the system. Let's now move on to POPIA complaints. When non-compliance occurs, individuals need to be able to exercise their rights by complaining to the regulator. And historically, this process has been manual and not very efficient for both us as the regulator and the users, the public, let me put it that way. So I'm happy to share that now users can lodge complaints on the e-services portal. We went live with this a few months ago in October, and it covers all of POPIA-related complaints, including unsolicited direct marketing. We have a separate category for this. And yeah, in just those 3 months that we've been live, we've received over 900 complaints. And this is before any formal communication has been done to the user. So these are people that are just logging in onto the portal, and they discover that you can now lodge a complaint online. And there are some that are submitting manual complaints, and then they are redirected to the online platform. But I'm just wondering what it's going to look like when you start doing some marketing around it. So those numbers might jump up drastically. Transparency is a critical pillar of accountability. So we provide some tools, and these tools are public-facing, and these allow people to check whether an organization is compliant. Are they registered with the regulator? Who's the information officer? They can check, do they have a POPIA manual? Do they submit their annual report in the previous financial year? Things like this support due diligence, and that supports as well informed decision-making by both organizations and individuals. So this is available for anyone who's logged in on our portal. So you can just log in and check on any organization that is registered with us. And since we are in Polokwane today, this example shows how public bodies in Limpopo are complying. I think this kind of visibility matters. It encourages accountability without needing enforcement, and it's available again to everyone who wants to view this. The first screenshot that I've got on there is the provincial government, and it looks like all of the provincial government departments are compliant. They're all registered, except for one that did not submit their POPIA annual report in the last financial year, but compliance there is fairly good. When we come to local government, though, municipalities, the picture unfortunately does not look good at all. Out of the 29 municipalities that we've got in the province, only 12 of them are registered with the regulator. So I'm hoping that the people that are here from the public sector in Limpopo can, advise their colleagues to start complying. On the right-hand side of the screen, you can see a breakdown of everything that is in a specific category that you've selected. So if you selected municipalities in Limpopo, for an example, you'll get a list of all of them, and we'll show you which ones are compliant and which ones are not. We've also looked at a multi-channel approach. It has been proven that compliance improves when services are available where users already are. We've got over 2 million active private companies in the country that are registered with the CIPC, and most of these interact with the CIPC on a at least annual basis when they do their compliance, like submission of annual returns. So we thought by integrating some selected regulator services with the CIPC Biz Portal will then reduce friction and make compliance part of normal business activity and hopefully a bit easier. And importantly, this integration is done securely using APIs. And the data that we collect from that system does not even touch the CIPC systems, even though you access it from a CIPC system, but the data goes directly to our databases without touching the CIPC environment. So that's just an example of what the Biz Portal integration looks like. We've got a list of services there that we've made available. One other thing to note is that now when you search for any company on the CIPC side, it will show you whether that company is compliant with the regulator or not. And we're hoping that will also push compliance on our side. As I wrap up, looking ahead into the future, I think the focus begins to shift from compliance enablement to privacy innovation. Globally, there's increasing attention on privacy-enhancing technologies, data minimization, automation, as well as AI. And for regulators, this means being thoughtful and forward-looking. We do not need to rush, but we need to also not stand still. So we need to start taking steps into looking into these technologies, and I think that's exactly what we're doing at the regulator. We've started looking into some of these technologies, and hopefully we'll start looking into implementation as well soon. So to conclude, after 12 years of POPIA, the debate is no longer about whether privacy matters. The real question here is whether our systems make privacy practical, accessible, as well as enforceable. When we build systems, we need to enable compliance, we need to empower individuals, improve transparency, as well as strengthen accountability. And I think if we do those, it'll move us closer to our goal. I want to end this by saying that innovation without accountability undermines trust. Accountability without, so let me say that again. Innovation without accountability undermines trust. Accountability without innovation limits impact, and POPIA requires both. Thank you so much.
Okay, so we have time. Thank you very much to our speakers. We have time for 2 questions. Are there any questions from the audience? Okay, we need a mic over there, please, for Mr. Dimba.
It's on. Oh, okay. Thank you for the opportunity. So my question is for both of the speakers. So Dr. Mtsweni actually mentioned about inserting data into large language models, that whatever data that you insert into the LLMs can actually be used to train the LLMs. So in terms of Section 5 of the POPIA, data subjects have the right to object to the right to correction, destruction, or the right to deletion of their personal data. So now, in these large language models, once a person inserts their data, it is now inside the AI, if I can put it that way. One of the most important conditions of POPIA is accountability. So now, can a data subject request an large language model company to actually delete their data or actually correct, or in terms of what the wording that POPIA is request a destruction of their data for the purposes of training the AI model? If that cannot be done, does that mean, how do we answer the question of who is now accountable for the processing of that data, because now the data cannot be deleted, or the data cannot be corrected or distracted? So who will now be accountable? And if we have a question mark of accountability, how will we go forward in innovation if personal data cannot be protected when AI models are being used? Because every time someone inserts the data, it's being trained. But now who will be accountable if there is a request for deletion, but then the deletion cannot be done because it's already in the AI? Thank you.
Perfect, thanks for that question. Next question, I think it was Mr. Dimba.
I yield. I was going to ask exactly the same question.
Okay, perfect. I see you guys are in sync. Okay, no, good. Please go ahead.
Thank you for the question. It's a very difficult one. But ideally speaking, just like when we speak about other technologies, whether it's Google and the likes, if you ask for your data to be deleted, most of the terms and conditions allow. But the question is, as they always say, once your data is there, your digital footprint is there, it's very, very difficult to, what can I say, to wipe off your data from the internet. It's very, very difficult. And the main reason is the internet, the way it works, it archives the data on a regular basis, and that personal data, in as much as it may be, let's say, distracted or removed from the LLMs, but it does not necessarily mean these LLMs, particularly if they're interfacing with the internet, they can't find it from other sources. So that's it. That is why even today you find people says, I want to wipe off my name from the internet, but it's just really, really, really difficult. But from the, as I said, ideally speaking, and from an accountability point of view, generally big companies, would do it. But whether that can help or not is another story. I think that's how I can answer it. I don't know if Luyabo want to add.
A difficult one indeed. Is this on? Yeah, it's a difficult one. But once you put information online, it's very difficult to get it off from the digital footprint. We often advise that you limit what you put online, because once it's on there, it's difficult to get off. But Jabu has mentioned that it's possible that you can request for deletion of this information, but whether it completely is removed, it's debatable at this point.
Perfect, thanks. And if I were to just add a bit to that, it would be that what has emerged globally, at least, is that it is a difficult question, and even the biggest companies, the biggest technology companies, are struggling with how do you untrain a model, which is basically impossible. And so what they do instead is they just turn off that specific data set or requirement. And in severe cases, what other regulators across the globe are considering is a concept known as algorithmic destruction or retirement, where the entire model needs to be destroyed and then retrained. But that's in the most severe situations.
In the US,
oh, it's off. Oh, yeah.
Okay. So in the US, the FTC would order what they call a disgorgement order to make sure that that data is deleted out of the models. You need to be very careful when you engage with these tools. Read the T's and C's and the privacy clauses and make sure that they don't use your data that you use for prompting, for training, And that's why they would usually say if it's a free version, they would use your data for training. And so getting that into your data into their models is going to happen. If you use licensed versions, that would typically not use your data for training. And to your point around regulators ordering, things to be done where information was unlawfully processed into a large language model, South Korea has ordered Alipay, Apple Pay for deletion of the entire model and a fine because they processed information illegally. So those avenues do exist, but again, it's a very difficult exercise to make sure that your data is deleted. So upfront, don't use personal information for model training, and also don't disclose unnecessary information into your modeling as well.
Perfect, great points on there. Are there any other questions? Are we good? Okay, so we are done with this session. Thank you very much to the speakers. Regarding the way forward and the closing of today's session, I'd like to call on Mr. Mfana Gwala from the Information Regulator to close these proceedings, please.
I thought you were going to wait with me before. Now I'm playing. I'm joking. Thank you, Nathan Rose, for a job well done. I think let's give him a round of applause. Yeah, you've conducted today's proceedings with diligence, and thank you for that. Yeah, in the regulator, I think it's becoming a habit now that I remember I did this once about the way forward. Now it looks like it's a job that has been allocated to me now. And unfortunately, I'm a very slow typer, so I still use the ancient ways of recording what has been said. But let's get on with it. I'm just highlighting issues. You know, at the end of a class, you need a summary just to remind yourself what are the important aspects that were spoken about. And especially from the perspective of the regulator, because this event of today is very important to us as a regulator because we got to share different experiences from different private bodies, public and private, NGOs, academics, and so on. And it goes a long way in informing us in our work and also understand what problems people encounter in interacting with the regulator. And we always emphasize the issue that as much as we've got the whip, and I think we've demonstrated that we can crack the whip, but we always try and encourage compliance voluntarily. That's why sometimes you'll find that we've spent a lot of time doing assessments and advising. No, not advising, because we're not supposed to advise, because you can't advise and regulate, because at the end of the day, if you don't comply, then you meet the wrath of the regulator. So we've guided people to try and encourage compliance. And we hope that that will go a long way in terms of encouraging compliance. We understand that this is one of the aspects, and there are many competing aspects in terms of compliance. And in terms of business, people will say it increases the cost of doing business. But unfortunately, it's important that we should do these things. The chair did emphasize the fact that, what we're talking about today, the right to privacy, sits at the top of human dignity. So it's not just a superficial thing that we're doing. And privacy now, I don't think we ever thought that it will come at a premium as it is today. In the past it was easy. You lock yourself in your house, your privacy is a little bit secured. But today, it's difficult. So yeah, it's important that we look at it in that perspective, that it is a human rights. It's a human rights issue, it's a human dignity issue. And you've seen what has happened with regard to that. And I think the chair also just repeated what is important, children. You know, in the past, our parents used to tell us when we asked them, where do children come from? And they say, no, the aeroplane brings children. Our children now, they know exactly what happens. I've seen some AI videos here where children, they are engaging with their parents that you lied to me. You said my sister came from this and this. You didn't tell me that, you know. I don't want to be graphic about it, but our children know exactly what is happening, even if we pretend that we don't know, but they do because of these gadgets. So it's important that as much as we use gadgets to keep children occupied, but it does not derogate from the fact that you still have a responsibility and accountability to make sure that you protect your children from the harm that may come from the consumption of these data. The chair also, emphasized the fact that there's still a gap on the awareness about POPIA and privacy, basically. There's still a serious gap there. And I think the research, and I'll speak about that, that was a report that was shown to us by Ms. Shelembe, demonstrate exactly what we're talking about. And I think ultimately the purpose of this conference is to make sure that ultimately we make compliance with privacy laws practical in order for it to be achievable, encourage organizations to promote privacy in their own institutions and not wait for the regulator to come with the whip. The public, the results, and I'm not going to repeat, but I think what the survey that was presented here by Ms. Shelembe simply says people do not know about the regulator. They have no knowledge of the regulator and its function. 70%. Essentially, we are trying, but it's clear that people are still ignorant about the information regulator and its functions. Especially in rural areas, which is a concern for us, especially because we've got a program as the regulator that started by targeting townships and rural areas. And I must say, it's quite interesting. In our Dikopano program where we go to rural areas, there would always be a drama performance done basically by the people from there. And it's so informative, and when we watch it, you realize that there seems to be an awareness about the issues of privacy and so on. But from the research that we're getting, it means we need to look at enhancing the way we interact. Language barrier, I think we know that some of us here are lawyers or accountants or doctors and so on. And we sometimes get consumed in the language that we always use, which alienate our people, which is the jargon and the technical language. I think the reason why a lot of people don't understand what we're talking about, we are too technical about it. So we need to simplify in creating that awareness and interacting with our people and make sure that we were able to reach out to those people. Well, some people are aware of their privacy right and are aware that 30% I'm talking about has been violated. However, they still don't know. In fact, they still don't know that they can approach the information regulator and you don't pay a cent. And in fact, even people who are sophisticated, like political parties, I think it took one judge to insist that people, before they approach courts, they must approach the regulator. And I think ultimately it's going to be the law, because political parties just run straight to court for a matter that they could come to the regulator. But we accept that sometimes there are challenges in terms of capacity and so on. And then there was an issue raised about digital literacy rate, that we need to look at that as well. What we also heard today was that POPIA has opened new career opportunities. And it's true, I can attest to that. People now are doing master's degrees in privacy, the impact of privacy and economic systems. In fact, there's a book that I showed the chairperson. The title of the book is Data Grab, written by one professor from the US, Ulysses Mejayas, and Nick Couldry from the UK. Essentially, what these guys are saying is that what is happening now, it's like the continuation of colonization. And they use 4 axes. They says, you know, the system that the colonizers were using was the 4 axes: explore, exploit, extract, and exterminate. Explore, they come to you and say, we come from His Majesty. And I'm not referring to anybody because I can't be talking politics. We're talking politics of data, not politics as we know them. They come and explore and say, hey, this is who we are. We're sent here by His or Her Majesty the King. You've got resources here, and these are resources we want, and we're going to take them for free. If you have a problem, we will deal with you, and we're going to use you to get these resources, because then it becomes cheap for us. Sometimes we use people as slaves. We don't have to pay them at all to go and dig these resources. Or we pay them a little bit. But then we use that, we exploit that for economic gain. So what they've done, they take those resources, they develop their own country. Same thing is happening with data. You download an app, terms and conditions, you don't read, but basically what they are saying, you've got data, it's important to us, it's cheap, we're going to take it, and you must know that you're not going to get a cent out of it, but we are going to make a lot of money out of it. We'll exploit it for economic gain, and we'll extract it, and don't expect, if there's resistance, we'll deal with you, exterminate. So the same principles are happening as we speak now, but I don't want to go too much on that. So essentially, that's what is happening. You give them your data, they use it. You know, the richest companies now in the global stock market are tech companies. The first company to hit the $1 trillion mark was Apple, for the first time. So data has become a new gold or a new oil. Yeah, and there's a problem that especially us as the regulator, which is an organ of state, unfortunately, you know, innovation moves very quickly. It's very fast, but the legislative process is the slowest. And it doesn't keep up doesn't keep up with the innovation. And sometimes it stands on the way of innovation. And that's why I've written here, I wish Parliament could start using AI maybe to develop legislation very quickly. As long as it doesn't hallucinate. But then probably, I mean, we've sent amendments for POPIA and PIA. They've taken time. Probably that's what we need to look at. Parliament needs to look at itself and see that technology is advancing at a lightning speed, but unfortunately legislation is remaining behind, and as a result it affects regulation. Another point was that we need to understand that privacy, and this is what I think Amanda said, privacy must be practical and agile. I can't agree more with that. It's like culture. Culture must be practical and agile for people to continue to respect it. Same applies to privacy. For it to be effective and for us as regulators to be able to regulate it, must be practical and agile. It's important that we form partnerships with institutions. We can't overemphasize the issue of privacy by design. I don't want to. It was clearly defined here, and that's what we're encouraging as the regulator. And then I think it's Dr. Jabu Mtsweni. I think he showed us some scary statistics there. Key insight for the South Africa data protection ecosystem. He has told us that data theft has increased. So it means that's why we're talking about security compromise or data breaches, which is keeping the regulators or giving the regulator sleepless nights. And the problem with AI is that there are no limits. It continues to process information. There are no limits. So we need to look at that, and because the conditions of lawful processes talk about limitations, processing limitations. With AI, it continuously, once it's there and it has picked up the information, it continues to process it ad infinitum. And then, I think the issue of privacy by design was the common theme amongst a lot of speakers. And then there's a need to deal with data protection threats, and that's where the regulator also comes in. But I think Mr. Mazibu's site meeting dealt with that issue. We can't overemphasize the issue of security safeguards. I think we've spoken about those over and over again. And we see that whether it's private or public, these continue to be a problem. And we always assume that the private sector has resources. They can always put resources in place and make sure that they've got proper security safeguards. But with the breaches that we've experienced, it shows that they are inadequate. I think the last group that was here, I think what the regulator, the message is giving to you through Mr. Luyaba is that we've digitized our processes to make it easy for you to interact and comply. I think that's the most important thing. Comply and easy to lodge complaints with the regulator. And I must say that we are grateful to our CIO and our ICT team. They work very hard in coming up with innovative ways of dealing with our systems. That's why now we're able to register a higher number of information officers. In the past, it has been a challenge. We're getting people reporting data breaches or security compromises. And I agree with you, Dr. Mtsweni, there's a lot. It's just that some of them are a little bit minimal, but they happen every day. Somebody sends an email to me, but it lands to Ntate Musala. That's a data breach. You post something on WhatsApp, you think you are posting to a certain group, whereas it goes to another group. That's a data breach. So it shows that there's need to create more awareness in that respect, but at least the regulator is working very hard to try and simplify and promote access to its services in order for people to comply. But we still deal, I know people will say, but what about people in rural areas? We still allow people to walk in our offices and report. It's just unfortunate that for now, we do not have capacity to expand offices to various provinces, but like the chair said, that's why we're here in Polokwane today, to make sure that now and then we interact with people, we remind people that we exist and we're there to help them to comply, and we're there to help them enforce their rights to privacy. With Home Affairs, I think Home Affairs, what is a takeaway? Home Affairs would like to see the regulator interacting more with organizations such as the Home Affairs in terms of training and in terms of partnership. And I must say that because I think all of us understand, especially organs of state, our resources are very limited. And therefore it becomes important that we partner. When you have a session, departments and organizations, they always have sessions, whether it's training session. You invite us, we partner with you, we deal with issues of privacy and promotion of access to information. And align privacy with the legislative process. The process of promulgating legislation is still archaic a bit. You still have to publish in the government gazette, and sometimes you publish personal information in the government gazette and let people comment about that. What is of concern to Home Affairs, and I think also to the regulator, is that we need to find a way, to align, to bring the process of making legislation in speed with the advancement in technology and the new privacy laws. And from the discovery point of view, I think this is a very important point. It is important to embed privacy as a business capability. And I think that's what even public organizations were saying in some of the site meetings, that we need to link privacy with business, not as a compliance issue where we just tick, 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 sent to the head office, to the Premier's office. We've complied, we've achieved our APPs and so on and so on, right? Also that we need to understand that as the world changes, privacy continues. So it doesn't mean that when the world changes, privacy doesn't continue. So we need to embrace that as a philosophy and continue. That's why I'm saying it's a pity, because you see, companies are quite quick in bringing new systems. But as regulators, we move a little bit slow, to bring legislation and regulations in speed. Like now we're battling with AI, and it's a reality, it's there. A lot of people are using AI. Young people are no longer reading books when they do research. They just go to AI, and that's why there's a whole lot of hallucinations. And in fact, lawyers as well have been caught out where they started quoting cases that do not exist. And I'm sure those lawyers have lost their licenses as we speak. So, yeah, I think those are the issues, those are the takeaways that we need to consider when we think about the way forward. We are grateful that we're able to bring a lot of stakeholders today and then to deal with these issues. Like I said, I can't overemphasize the importance of these interactions as the regulators, because what is also challenges for you, we want to hear what is the difficulty with you in complying, because we understand. I mean, I'm a practicing attorney. Right now, there are a lot of attorneys that have been fined by the Financial Intelligence Center. And the fine is, it's the issue of money laundering and so on. And there's a case where I'm representing the LSSA in that case. They fined a law firm which is doing estates and conveyancing, and there's another one which was doing conveyancing for government, 7 million, and the other small firm, 200 million. Now, the problem with that is that in South Africa, we have about 35,000 attorneys. And out of that, almost 70% of those are single practitioners. And when I say single, like criminal lawyers, we always make a joke. When we go to court to represent your client, your left pocket is your trust account. So the client gives you the deposit, you put it on your left pocket. That's the trust account. As you finish with your bail application, you move the money to your right pocket. Now that is your business account. So if you tell a person who's struggling to even file an annual audit to the regulators, and then you tell the person now you have to comply with FICA, now you have to comply with issues of money laundering. You must put in place cybersecurity issues. For an example, I'm told that just to comply with the requirements of FICA, minimum you need about 40,000. So if you are an attorney who's not even making 20,000 a month, how are you going to comply? And this affects businesses across. And I think that's where the issue of the cost of doing business becomes an issue, and by that very fact, it affects the economy. So we understand that balance, but unfortunately, it's something that we need to find a balance, a very careful balance between the two. Thank you very much. My boss is complaining that I'm talking too much. Thank you very much. I think it was supposed to be Advocate Strom to do a vote of thanks. Oh, the CEO says I can do that. It's a simple one. Thank you very much to our service providers. Thank you very much to all the private and the public bodies who attended this session. Thank you very much to our panelists who gave us a lot of wisdom. And thank you very much to the participants in general and the team that has organized this conference. And thank you very much. Enjoy the rest of your day.